Good morning, all.
Morning, Chair.
Another day, another week. Well, if I may remind the witness, you are still under oath. You're being cross-examined. You ready to go, sir?
I am.
Yes.
I'll be brief.
Thank you. You may proceed.
President, I just wish to sort of telescope that I'll be very short today. I'll summarize by referring to the terms of reference. Good morning, Mr. Tinswai.
Good morning, sir.
You will recall that on Friday, I referred you to the terms of reference, specifically relating to what the complaints before the tribunal
Yes.
are about Judge Makhubele.
Yes.
I wish to go back to that, and for reference, it's at volume 3. Volume 3 at page 1033, so that's 1033. And I'll read it for you and then put the questions if you haven't accessed it yet. The particular charge I'm referring to, or complaint, is the one that says that whether the respondent's conduct was incompatible with the office of a judge in that she marginalized the PRASA legal unit and terminated or caused to be terminated the mandate of PRASA's attorneys and personally appointed another firm of attorneys in their stead to represent PRASA. Did Judge Makhubele appoint a different set of lawyers to finalize the CIA matters?
No, Chair. She
So
stuck to the same lawyers, Diale Mukhashwa Incorporated.
She did not terminate any mandate insofar as the CIA matters were concerned, correct?
So I'm not certain, Chair, what this is referring to. But I think there's a bit of a confusion between maybe the mandate of Bowman's and the mandate of CIA. But I think the charge is a little bit confused. Judge Makhubele continued to use Diale Mukhashwa, but she indicated to the lawyers of CIA that the mandate, that Bowman's didn't have a mandate to represent PRASA.
Yes, so she didn't terminate anyone's mandate, correct? Any law firm's mandate?
Yes.
Nor did she personally appoint any firm of attorneys to handle the matter?
No, she didn't, but I mean, she was working with Diale Mukhashwa to proceed with the settlement, Chairperson.
And Diale Mukhashwa, to round it up, I apologize. Diale Mukhashwa was originally handling the matter before she arrived, and they continued to handle it when she was seeking to settle the matters.
Yes.
Thank you.
That is correct.
Chairperson or President, those are my questions. I've already confirmed with Mr. Malika that that's what I'd be asking, but just to ask if he's happy, Judge. We are done, President. Thank you.
Thank you. Is there any re-examination from your side, Ms. Sungu?
Chairperson, I have no re-examination.
Thank you. I just want to ask you, how many meetings did you personally have with Judge Makhubele?
I think the one of the 9th, Chair.
9th of November?
9th of November. And I think at that meeting we didn't have any discussion about this matter of CIA in particular. It was just a general discussion around the legal department and the worksmen's investigations. So in relation to the matters of CIA, no meetings at all.
is your answer then, you didn't have any meetings with Judge Makhubele after the 9th of November?
Correct, Chair.
So from that answer, I understand that you didn't have any meetings with Judge Makhubele concerning the CIA matter.
Correct, Chair.
After the 9th of November, when did you then get involved, if I may put it that way, with the CIA matters, you personally?
Chair, I think on the 15th, I made an inquiry with 15 December.
Yes.
Sorry, 2017. I made inquiry with Mr. Mokhashwa about where these matters were. That was after the meeting that he had with Judge Makhubele, thinking that I was part of that meeting, and I wasn't. So I just made the call. And then the other occasions would have been when there were attempts to process the payment. And
Well,
that
let's take it one at a time.
yes,
So you met on the 9th of November, but there were no discussions involving the CIA matter, is that correct?
correct, Chair.
On the 15th of December, you had telephoned Mr. Mokhashwa, is that correct?
That is correct, Chair.
And you wanted to know how far the CIA matters have progressed, if I may put it that way.
That is correct, Chair.
And then when was your next involvement with the CIA matters?
It would have been around January or February 2018. And it came from an inquiry that I received from, I think, a lady who was a PA to the CFO of the division called Prasa Tech. They were asking me for invoices because I think what they had received was a letter from Matopo attorneys asking for payment. So they were asking for invoices that related to those payments.
You say it was around January, February, you can't be more precise.
Yes, Chair.
And it was from Prasa Tech looking for invoices.
Correct, Chairperson. The email is in the bundle. I was referred
Yeah.
to it earlier. Yes.
What was your response to that?
Well, the response was that those claims came out of a settlement that was dubious.
No. I don't want commentary. So you get the call. The call is that the person on the other side from Prasa Tech, you say,
Correct, Chair?
is looking for invoices.
It's an email, Chair.
Sorry, it was an email.
Yes. So what I'm stating, Chair, is not commentary. It's the response that I indicated that those payments were claimed based on, I'm not certain the words I used, but questionable settlements that were reached by the chairperson, the then chairperson of the board, Judge Makhubele, without involving the legal department. And I think I also advised that payment should not be made on those invoices.
Yes, and then what other personal involvement did you have with this matter? And with whom?
Then it was a call from a former colleague who was representing a client that was claiming monies from Mr. Mackenzie Mabunda. And this colleague wanted to confirm that there was an imminent payment coming from PRASA to Mr. Mabunda. My sense from the call, Chair, was that Mr. Mabunda had promised this colleague's client that he will be making payment soon, and that the payment will be coming from monies paid by PRASA.
Yes, and the next involvement you had with anyone that you can recall?
So, Chair, I think just to place a date on that interaction would be around the 5th of March, 2018. Thereafter, I then requested the papers from, I called Mr. Mkhashwa. I asked him what was happening in the matter. Mr. Mkhashwa was very relieved to receive my call, and he told me that they had received an application to make the awards, arbitration awards, that were made based on the settlement orders of court. I then requested him to furnish me with those papers. And then he did, and we made application to set that aside.
Did you inform Ms. Ngoye what you have discovered, or were you working with her throughout?
We're working with her throughout, Chair.
I see.
So when I received these news, I reported to her. And when I received the papers, I also reported to her. When we received a strange letter from Matopo attorneys, which had two transcribed texts that were alleged to have been sent by Judge Makhubele to the lawyers of CIA, I also informed her. So she knew everything, Chair.
Yes. And then it was from the 5th of March onwards that litigation commenced from PRASA side.
Correct.
And that litigation involved just precisely what?
So, Chair, firstly, we opposed the application to make the awards. That was unsuccessful.
When was that?
Chairperson?
When did you?
The application was set down for the 9th of March, 2018.
Yes.
Because of the text that had been sent by Judge Makhubele to CIA's attorneys, which was placed before court, the presiding judge in that matter believed that the attorneys, the lawyers acting for PRASA were not authorized, and granted default judgment against PRASA.
Did you yourself see the text?
I didn't see the text. The text was, the transcript of the text was contained in a letter. So the exact text was transcribed and placed in a letter. There were two, Chairperson, that were transcribed and placed in a letter. So there was one that was addressed to the attorneys or the lawyers of CIA, and there was one that was addressed to the then acting Group CEO, one Cromet Mulepo. So on the basis of that text, default judgment was entered against PRASA.
Yes, and we know subsequently there was an attempt involving Bowman's to have the default judgment set aside.
We were successful, Chairperson,
Yes.
in setting those aside,
Yes.
in rescinding them, sorry.
Yeah, thank you.
Oh, yes, thank you, Chair. Mr. Dingasai, just to understand your background, Judge Makhubele found you there at PRASA in October 2017. No?
That is correct, Commissioner.
By then, were you an admitted attorney already?
Yes, I was admitted before joining PRASA.
You were admitted when?
In 1999.
99.
Yes.
And when did you start practicing for your own account?
Chairperson, I practiced privately until,
When did you start?
so from admission, I was practicing until 2013 when I joined PRASA.
Yeah.
And then I was at PRASA until, I think I must correct that I gave the wrong dates. It was 2021, January 2021. I think previously I testified that it was January 2020. So I stopped working for PRASA in the end of January 2021, and I'm practicing at the moment from 21 to date.
And what was and what is the nature of your practice? What does it involve, generally?
I've been fortunate that I have managed to practice a broad spectrum of the law. I've done civil litigation, I've done commercial law, I've even gone into very specific things that are not generally done, like medical schemes. I've had a little experience in mining law. PRASA exposed me to a lot of engineering and construction law. So I count myself as fortunate, Commissioner. I've managed to practice a very broad spectrum of the law.
In commercial law, including dealing with tenders?
That will mainly be public law, particularly, I mean, I did it before entering PRASA and also at PRASA. So when it comes to, for an example, whether, as I testified, whether a public entity can enter into an oral agreement or a partly oral, partly written. I mean, those type of things in public law my understanding is that 217 of the Constitution prohibits such. So it's not possible or permissible for a public entity to enter into such contracts. So I mean, even now in practice, I've had exposure to public law. I was assisting a client with a review application around 2021 after I left PRASA.
I must also ask you, what was the relationship between you and Matangoye and Mr. Lindekaya Zide, is it, at PRASA? Was it a cordial relationship or did you have problems?
Lindekaya Zide, I know from university. We went to the same university.
Yeah.
And I met him after my appointment at PRASA. He was the company secretary. I was a general manager in group legal services. We were very happy to meet each other. We had a very good relationship and a good friendship. I met Ms. Ngoye because he was one of my internal clients. She was, apologies, I said he. She was the CEO of Intersight, And so the legal department supported Intersight. That was before she moved to become my boss at PRASA. We've enjoyed a very good relationship. We've worked very well together. I think she's one of the most, the leaders I respect the most. She knows her work. She knows what's supposed to be done. And I think in terms of understanding the business of PRASA and a lot of other nuances in PRASA, at the moment, she's unparalleled.
And your relationship with Judge Makhubele from October until she left in March of 2018, how was that?
Commissioner, like I said, there's a pecking order.
Sorry, we're not commissioners here, we're actually members of a tribunal. You've been using the word commissioners all the time.
I apologize,
Yeah.
Judge. As I said, there's a pecking order. So I only met Judge Makhubele on the 9th, and I must say, when she was appointed, I always check who's appointed. When the announcement comes, I go on Uncle Google and check what information is available about those people in the open platforms. And I came across an interview of hers at the JSC.
Well, I just want to know what was the relationship like.
I didn't
With
have
the
a
judge.
relationship with her, except for that meeting. That's all that. That's all the interaction that I've had with her.
Thank you, Chair.
President, if you could indulge me, there was a reference to a provision in the Constitution, and I wish to read it to Mr. Dingeswayo and ask which part of the text says what he claims it does.
Yes, certainly, put the question.
Indeed. Mr. Dingeswayo, you said that Section 217 of the Constitution doesn't allow oral agreements. Do you by chance have it before you, or are you happy for me to read it to you? Because I'd like for you to.
Please read it for me.
So it has 3 subsections, as you'd know. The first is subsection 1, and it reads, when an organ of state in the national, provincial, or local sphere of government, or any institution identified in national legislation, contracts for goods or services, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. Stopping with the first subsection, where does it prohibit oral agreements, that provision?
I think, Chair, when I gave evidence, I said that the provision that those 5 qualities of the system that a public entity should use to enter into agreements militates for written agreements. So if he's saying it must be fair, it must be cost-effective, etc., you can't determine that from an oral agreement, because with an oral agreement, all you are left with is one's word against another's. You will not be able to do that. And I'm not aware, Chairperson, of any public entity that enters into oral agreements.
You accept, though, that subsection 1 of 217 does not prohibit oral agreements, nor does it prescribe that agreements should be written, at least the text of it?
Yeah, it prescribes that you, you should enter into the contract which is informed by a system that is fair. Now, I'm saying, and I mean, I've been consistent. This is what I've been saying the whole time. This is the justification that I've been given, that you can't get all those 5 qualities from an oral agreement. Once you have an oral agreement, things are hidden. Then you just depend on certain people to come up with to show you those things. So you asked me about, you made reference to Odekral and said it's binding until it's set aside. With an oral agreement, how do you do that? What do you present before court?
Section 2171 does not prescribe the type of agreement. It only speaks to a system through which procurement should be done. I'll move on then to subsection 2. And again,
No, you don't need to go there. That's the basis. So you don't need to go to 2. I mean, if we are not at one with you that section 2171 implies that contracts must be written. If I'm not at one with you, we're not at one. So 2 and everything else is not going to assist the debate.
thank you. So your contention or assertion is that it implies it.
Yes,
Okay.
I'm not saying it's written
It's
there.
not written.
No.
Thank you. Thank you, President.
Yes, thank you. I don't believe anyone has further questions for you. Then you are excused.
Thank you very much, Chair.
Thank you, Chair. The next witness that I'll be calling is Advocate Boetus, but at this stage, Chair, I am going to request for a short adjournment. There's an echo. I'm going to request for a short adjournment, but
Well, we'll take a short adjournment. You let us know when you're ready. And if you can, just sort out that echo, please. Well, ask the relevant people if they can.
Will do so, Chair.
Thank you.
Chair.
Sorry, the mic was off. Well, welcome, Advocate Boetus.
I apologize,
Yeah.
Chairperson.
What remains for me to do is for me to swear you in. Please raise your right hand. Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Say so, help me God.
I do, so help me God.
Thank you.
Thank you, Chairperson. Before I start leading the witness, I need to just make a comment, Chair. We are going to be leading the witness today. Hopefully, we will be finalized soon. Then council can determine whether they'll cross-examine. Chairperson, Advocate Boetus is not available tomorrow, so we couldn't waste any more time. We have to call him today, and then if any other evidence is outstanding, it can be laid on Thursday. He'll be available on Thursday. Mr. Makhashwa will be available tomorrow and Wednesday. Thank you, Chair. I just needed to put that on record. Thank you. Advocate Boetus, you're an advocate and you are at the Pretoria Bar.
That is correct. I'm an advocate of the High Court of South Africa, and I'm a member of the Pretoria Society of Advocates since the beginning of December 1997.
You can leave your mic on. Yes. What are your qualifications?
I hold an LL or a BLC, Baccalaureum Legis Cavilium, and an LLB at the University of Pretoria, which I received in 1995 and 1996, respectively.
Okay. Now, prior to October 2017, did you know Judge Makhubele?
Very well.
And how did you know her?
Like I said or indicated in my statement, that I know her since 1997, I labored under the impression that Judge Makhubele is my senior and that she was a member of the Pretoria Society of Advocates prior to me becoming a member of the Pretoria Society of Advocates. It seems that was a mistake, as Judge Makhubele indicated that she became a member of the Pretoria Society during 1999. I accept that. So I met her in 1999. We became good friends. We were members of the Bar Council for more than one stint. And when Judge Makhubele was the chairperson of the Pretoria Bar Council, we supported her. I was a member of the Pretoria Bar Council for a period of more than 10 years. And yes, we had a very good, honest, transparent, cordial relationship. We knew each other well.
Okay. I want to refer you to volume 19 of our documents,
I have it in front of me.
page 45.
I have it in front of me.
It's headed Response to the Complaints lodged by the Honorable Madam Justice T.A.N. Makhubele, and it is dated on page, if you can go to page 61.
Yes,
Do you confirm your signature on that document?
that is indeed my signature on the document, and it's dated the 17th of May 2019.
Okay. Further than that, and that document, this specific document that you've just referred to, if you go to page 40,
Yes,
if Boetus' first affidavit, 14th of October 29, is that correct?
that's correct.
And over onto the next page, you then have an affidavit which ends on page 43. Is that your signature on page 43?
That is my signature.
And what date is that? on
It's
page-
been signed and commissioned on the 14th of October 2019.
And in that affidavit, is it correct that you refer to your response to the complaint?
Just to give it some context, after my response on page 45 was submitted to the Bar Council, and after the Professional and Ethical Committee of the Pretoria Society of Advocates responded to it on the 22nd of May 2020, somehow this alerted the attention of the Zondo Commission. I was then contacted by a certain Mr. Clint Ulerman, who asked me whether or not I was the author of this response to the complaint, which I indicated in the affirmative. They then subsequently made an appointment with me at my chambers, and they asked me three things. One, whether I am prepared to confirm the allegations and averments contained in that response on page 45 onwards under oath, which I said yes. Secondly, whether I'm prepared to surrender my cellular telephone and my iPad to them so as to make copies thereof and to verify whether the information contained therein corroborates with the information that appears from the response, all of which I said yes. I then had to give them a written consent, and they copied my cellular telephone and my iPad in the office, in one of the offices on our floor at Chambers.
Okay. Then I'm going to refer you to page 94 of the bundle.
Sorry, my pages aren't numbered, but yes, I will follow. Which annexure is that?
It's F. Botha's second affidavit.
Yes,
dated
I have it in
20.
front of me.
And you confirm that that affidavit was signed by yourself on the 20th of May 2020, is that correct? Signature
good.
appears on page 97.
That is 100% correct. Just to give it some context, there was some inquiry in response to what I've said and what was contained in paragraph 11.2 of my written response, and I just clarified certain issues that I was requested to do.
Okay. That is not a problem, Advocate Botha. Now, we will be making reference in response to your response, or will we be relying on your response to the complaint lodged by Honorable Madam Justice T.A.N. Makhubele, which is starting on page 45. And I just want you to indicate this, or the starting point is Siaya companies before October 2017. Were you in any way involved in any civil litigation with regards to those companies?
Yes, I was indeed. On or about May 2019, I was approached by two firms of attorneys, Matopu Incorporated and Krause Incorporated. I was informed that there were 4 matters pending before I said 2019, it's May 2017, not 2019, 2017. There were 4 matters which were set down in the High Court of Pretoria, Gauteng Division.
Sorry, Advocate Botha, a little bit slowly.
Sorry.
Yes, sorry, we're taking notes.
I'm sorry, I'm a little bit too fast. I realize it. I apologize. Sorry.
4 matters which were set down in the High Court.
Let me just go one step back. I apologize, Chair. I was approached in May 2017 by Krause Incorporated and Matopu Incorporated. My instructions were that there were 4 matters set down for hearing trials on the same day in the High Court of South Africa, Gauteng Division, and I was requested whether I was available and prepared to represent the plaintiffs with an S in those 4 matters. There were 2 plaintiffs, Chair, Siaya DB Consulting Engineers in liquidation, as well as Siaya Rail Solutions Pty Limited. In all 4 the matters, and may I just for the record the case numbers. The first one was 73933 of 2015. I repeat, 73933 of 2015, Next one was just one digit onwards, 73934 of 2015. And the other two, the first one was 47597 of 2016. That was where CIRL Solutions, Pty Limited, was the plaintiff, not in liquidation. And the last matter, Chairperson, was under case number 47598 of 2016. In all four of these matters that I've just alluded to, claims were initiated against the Passenger Rail Agency of South Africa for work done or services allegedly rendered. I confirmed my availability. We consulted subsequently, and it was evident for various reasons that not one of these four matters, Chairperson, were ripe for hearing. Counsel, who were instructed by PRASA, was a very good friend. I regard him as a very good friend. We know each other very well. Was Advocate Kennedy Tsatswane, SC, a member of the Johannesburg Society of Advocates. And after we've discussed the status of the four matters, and after we've obtained instructions, both Advocate Tsatswane, SC, and I were in agreement, Chairperson, that in order to expedite the matters, regard should be had to refer all four matters by agreement to arbitration. And after we've obtained instructions, Chairperson, that's exactly how it transpired. We've prepared draft orders to that effect, all four draft orders, which were presented to the Honourable Deputy Judge President, who attended to the call of the roll on the 30th of May, 2017, the Honourable Mr. Justice Ledwaba, and he made orders to the effect that all four matters are referred to arbitration before the Honourable retired Judge of the Supreme Court of Appeal, Justice Fritz Brandt. So it was then decided to make an appointment with Justice Brandt. Advocate Tsatswane, SC, and I travelled to Sandton. Judge Brandt at the time resided in Stellenbosch, Chairperson. He was at a specific time in Sandton. We made an appointment with him, and we saw him for our first pre-arbitration meeting at Chambers in Sandton. Just allow me, the purpose of this pre-arbitration, Chairperson, or the first pre-arbitration, was to establish whether or not there was a vinculum juris between the parties which was susceptible for arbitration. Secondly, time periods or time frames within which pleadings and notices would be exchanged, with specific reference to discovery, expert notices, and the like, and to establish the availability of all parties concerned for dates which suited everybody so as to set the matters down for hearing in arbitration. Oh, yes. No, if I can tell my story. Yes, sorry. I thought you wanted to follow up with me. Chairperson, it then transpired that the pre-arbitration agenda was then circulated. It was agreed upon, and the table was then properly prepared for the arbitrations to continue. In November 2017, Chairperson, and let me just interject for 1 minute, I knew that Judge Makhubele was recommended by the Judicial Services Commission to be appointed as a judge by virtue of media reports, which I read it from, and as a result of me being a member of the Bar Council, we always receive good news as one of our members are elevated to the bench. So I knew of Judge Makhubele's recommendation. I was totally unaware of the fact that she was connected or that she was deployed at PRASA whatsoever. It wasn't a matter of public record which I was exposed to. So during the first or the second week, the first week of November 2017, I received a call from Judge Makhubele. I immediately, Chairperson, congratulated her upon her recommendation. In my considered view, it was due, it was the right thing. She was, in my view, a suitable candidate. And the conversation steered into a direction of whether I was aware or involved in the Siyaya companies' litigation. Obviously, I was involved in the litigation as I was lead counsel. I immediately informed Judge Makhubele that PRASA was represented by attorneys, at the time Mr. Mokhashue of Dihale Mokhashue Incorporated, and represented by Senior Counsel Advocate Kennedy Tsatswane, SC. Judge Makhubele immediately directed my attention to the fact that, in her view, there are certain pending matters in which PRASA was involved in that should have been settled or sorted out long time ago. And what she indicated to me, as is the impression that she got, was that some of the attorneys who acted on behalf of PRASA was exploited, and personnel within the legal department of PRASA undermined the authority of seniors, board members, including but not limited to herself. And she furthermore indicated to me that she preferred regard being had to our long-established relationship to discuss and to ventilate these matters with me, and she, in so many words, indicated to me that she did not trust the attorneys acted on at the time on behalf of PRASA, and she also indicated to me that according to her, PRASA was captured by certain of its own employees and certain contractors. Chairperson, it was something that concerned me, regard being had to the fact that attorneys were already on record, as I've mentioned, and I immediately made contact with both Mr. Tsepo Matopo and Mr. Johan Krause. I conveyed to them the conversation between Judge Makhubele and I furthermore said to them, it's of paramount importance that whatever happens, Chairperson, must be above board, must be transparent, must be ethical. I'm not going to get involved in shenanigans, not at all. And it was then...
Just before you go on, you say you didn't want to get involved with shenanigans.
No, if I say shenanigans, he said, she said.
Yeah.
Afterwards, that there's a dispute insofar as what was communicated or discussed between the role players. I mean it in that sense, Chairperson.
Yeah, no, I understand. Did you then suspect there was something going on?
Not at all.
Then why did you raise this?
No, I was foreseeing problems that may arise as a result of me engaging with Judge Makhubele without the attorneys at the time who represented PRASA or Advocate Kennedy Tsatswane. That was the only reason, Chairperson. If I may, it was then agreed between us, if I say us, myself, Mr. Tsepu Matopo, and Mr. Johan Krause, that whatever is communicated between us would be recorded. In other words, if I receive correspondence, whether it's WhatsApps, SMSs, and whether I answer thereto or responded thereto, I would share the information with them, which I did, Chairperson. Various correspondence, let me first put it this way, there were numerous telephonic discussions between Judge Makhubele and I, all of which were to the point, cordial, and all of which, Chairperson, in my view, were in a bona fide and genuine attempt to settle the pending disputes. After our first engagement, or the first telephone call we had, or during the first telephonic conversation we had, Judge Makhubele expressly asked me to indicate to her what the status of the 4 matters at the time were. And I then said to her, what I will do is I will prepare a bundle of documents so that she can read it at her own time. She can ascertain for herself or decide for herself what the status of the matters at the time was. And Chairperson, what I did is I prepared a bundle of documents consisting of 17 pages. And a copy of that bundle, Chairperson, is attached to my response that I've just been referred to, marked Annexure B for Benny. Chairperson, if you just allow me, I'm just
Sorry,
indicating, I'm just paginating my own pages.
Sorry, Advocate Boites, I need to understand this. You say that during the first call, she asked for the status of the matters. Do you remember when was this call?
That was the first or the second week of November 2017. Chairperson,
Is the, and just so an understanding, you indicated that she had called and that's when you congratulated her.
that's the first opportunity I had, yes.
This call that you're referring to as the first call to her congratulating her, is this the first call in regards to the requesting for the status of the matters?
It was during the same conversation, yes. And I then volunteered to compile documents which I then said I would present to her so as to enable her, Chairperson, to consider the history and what transpired before our discussion. And that is the bundle, Chairperson, that you will find from page 64, that's marked with a B, 64. Is that the right page, page 64?
Sorry, Advocate Boetus. Can you rather refer to page 65?
Is it
It
65?
starts with Siaya Consulting Engineers.
Yes.
The company in liquidation, master's reference,
That's correct. That's Annexure B. There's a capital B.
yes. capital
Yes, sorry,
B.
then I'll just paginate my papers accordingly, sorry. So Chairperson, this is the document or the bundle of documents which I then compiled, and I then paid a visit to the headquarters of PRASA situated in Hatfield on the 14th of November 2017. If my memory serves me correct, Chairperson, that was just before or just after 1300 hours.
Can I just,
Yes.
sorry, interject at that stage? One has reference to this bundle, and it's written as with page 65 of this volume 19. It says Commissioner's Interim Report of the Inquiry in terms of section 4171 and 4182 of the Companies Act 61 of 1973, read with item 9 of Schedule 5 of the Companies Act 71 of 2008. What was this all about? This Commissioner's Interim Report? What was the, how did this come about, this report?
Chairperson, as a result of the fact that Siaya Consulting Engineers were in final liquidation, the liquidators decided to initiate an inquiry in accordance with the provisions of sections 417 and 418 of the Companies Act, the previous Companies Act, number 61 of 1973. I was tasked by the liquidators to attend to this inquiry. The inquiry, Chairperson, was set down for a whole week, during which Mr. Krieger was the chairperson. Mr. Krieger presided over these proceedings, and his first name is Neil Krieger, and he prepared this report, which appears from page 65 until page 75, subsequent to various witnesses who testified before him in this insolvency inquiry. And this report, Chairperson, is a very succinct reflection of the evidence that was presented before Mr. Neil Krieger. Can I proceed?
No, not yet.
Sorry.
Sorry, Chairperson. You say that you then took these documents on the 14th of November. To whom did you hand them to?
I had to check in at the ground floor. I was then taken up by one of the security personnel of PRASA, I think to the 3rd or the 4th floor, where the offices of the executives at the time were. I waited for a minute or two, and I was then taken to a big boardroom. Nobody was present in the boardroom. It was only me. I sat, and after a couple of minutes, Judge Makhubele entered the boardroom.
Were the documents handed over to him?
Yes, I made copies. I retained a copy myself. I indicated to Judge Makhubele, these are the documents that I have prepared so as to enable her to conduct whatever investigation she had in mind. We did not discuss the content of the documents, I was under the impression that personnel at PRASA was busy with their lunch break. I didn't want to keep anybody up, and after we exchanged a couple of words, I then left.
I want to take you to page 50 of your response to Judge Makhubele's complaint. Page 50,
I'm there.
paragraph 11.5.
Yes. I'm there.
Are you there? If you read that paragraph, this is in regards to, you will have to read it with reference to from the beginning of paragraph 11 to the conversation that you had, with the telephonic conversation. What specifically what did she request for you to provide, as noted in paragraph 11.5?
Chairperson, exactly what is provided for and alluded to in paragraph 8.5. The status of the matters, what transpired at the insolvency inquiry presided over by Mr. Krieger, and whether the matters were capable of being settled or not. Chairperson, if you have regard to my bundle, Annexure B, that's exactly also the chronology that I followed. I started off with Mr. Krieger's report, and then there was email communication between Mr. Mogashua and I on the 6th of September 2017, in which I directed his attention to various important aspects regarding the merits of the matter, with specific reference whether or not the matters could or could not be settled. Just by way of reference and just for clarity, on page 78, this is part of the bundle, and that forms part of my email dated the 6th of September 2017. The second paragraph from the foot of the page, it starts off with the words, "with the greatest respect." I said, with the greatest of respect, PRASA doesn't have a leg to stand on, nor does it have a valid defense in law. On its witness's own version, having regard to the benefit of doubt, the following amounts are, subject to verification and confirmation, due and payable to Siyaya. And Chairperson, I used the same case numbers, and those were 3.3 million rand, 8 million rand, 14 million rand, 15 million rand, 19.7 million rand, in total 60 million rand. And if...
Before you proceed,
Sorry.
Advocate Boetes, I want you to go to page 80 of that bundle.
I'm at page 80.
And if you look at page 80, there's an email just below dated the 5th of September 2017 at 20:47. So it is addressed to yourself from Mr. Makhasha. Do you see that?
I do see it.
Your response that, the email that you've just been reading now is dated the 6th of September 2017 at 10:10 in the morning. Do you see that?
That is in response of this email, yes.
So your response, your email was in response to the email from Mr. Makhasha, is that correct?
That's correct.
And what was Mr. Makhasha inquiring in that email of 5 September 2017?
If one reads the email, he says, "Dear Francois, I thought it fit that we deal with this in camera, with us being the parties' legal representatives. The position as we have it is that indeed you and Kennedy discussed the various options there may be regarding these matters, and as well our letter that had raised concerns regarding the plaintiff's readiness for the arbitration proceedings that are meant to commence on the 11th next week." That's the 11th of September. He says, "Apart from the fact that you may have expressed similar challenges regarding the plaintiff's readiness to start with its cases, and furthermore, outside of the activities that may be related to the liquidation proceedings outlined, has yet to agree to the postponement of next week's proceedings if it is communicated to it, and what the terms thereabout would be. In other words, there is no agreement to have the proceedings postponed, and that should it now be the plaintiff's position that the matters be postponed, that in that event, that should be communicated to us in order that we take instructions from PRASA. Consequently, we wish to consult with your clients regarding this. That you consult with your clients regarding this and revert to us at the earliest. We hope to hear from you, from your team soon. Regards. And that is my response.
And then you responded as of the email on page 76, from page 76 until page 78.
That's correct. Sorry, not page 78, page 80. No, page 80.
Page 80, sorry, yes. What was the essence of your response in that email?
There was nothing in this, well, there was not much in dispute. The reason why I say so, on a proper analysis of what was presented at the insolvency inquiry before Mr. Krieger, there were certain outstanding issues that needed to be attended to. And the witnesses chairperson who testified indicated and cooperated to such an extent that they agreed to obtain additional information and to come back at the later stage to the inquiry so as to present the evidence to the chairperson. That's why I used the words in my email, what I've just alluded to, and that is that certain of the aspects still needs to be verified and confirmed. But having said that, the bulk of what was in dispute, according to me and my understanding, chairperson, there were no real or meaningful disputes.
Okay. What then was your take with regards to the arbitration continuing the following week?
We agreed then, pursuant to the email that I'm the author of, that Judge Brunt would be requested to postpone the arbitration. The arbitration did not continue on the 11th of September of that year.
Just for the sake of clarity at this stage, before we go on, I need to understand, you have indicated that we were supposed to come back as a result that there were certain issues that had to be resolved. Was there a further inquiry in regards to that?
No, there was no further formal inquiry. What was also the sentiment and the understanding between the parties is that the outstanding information could have been provided to either the liquidators or the attorneys who represented the liquidators. There wasn't a real need or necessity for the outstanding information to be provided to the commissioner at a specific date during official inquiry under oath.
And Advocate Bottas, was this done? Are you aware whether this further information was in fact obtained by the liquidators or the attorneys?
No, I'm not in a position. Nothing was conveyed to me, and I didn't receive any of the outstanding information which are reflected and described in Mr. Neil Krieger's report.
At the 417 inquiry, which according to the reports by Mr. Krieger took place on, as indicated on page 65, the inquiry was held on 28 and 31 of August 2017.
That's correct.
What role did you play at that inquiry?
I was counsel who leaded all the witnesses.
Was PRASA represented?
Yes.
Were the employees of PRASA represented?
let me just go one step back. The people, the witnesses who were subpoenaed to appear at the insolvency inquiry chairperson were employees of PRASA. I invited Mr. Mokhashue and Advocate Tsatswane to be present for one reason. I thought if they hear the evidence and they are privy to what the real circumstances consist of, it will be much more beneficial for the outstanding matters to be settled one way or the other. I invited them to be present, notwithstanding the fact that it is an inquiry which in normal circumstances are attended to in camera. Yes, they were present on the 1st and the 2nd, my memory serves me correct, also on the 3rd day, the Wednesday, or if there was a day that we haven't sat, maybe on the 3rd day. But to answer your question, Chairperson, yes, Advocate Kennedy Tsatswane SC was present whilst the witnesses testified under oath, as well as Mr. Mokhashua.
If you can recall, Advocate Bottas, did they actually participate in the inquiry? If you can recall?
Chairperson, I can recall very well. They were present, as it appears from the record. They interacted very limitedly. I, on various occasions, invited Mr. Advocate Tsatswane to, if he has any question or he would like to elicit any further evidence, that he's more than welcome to engage, which never happened. So to answer your question, yes, they were present and they were interacting.
Okay. Let us go back to the bundle of documents that you then gave to Judge Makhubele on 14 November. Let us go back to that event.
I'm there.
You say that you then gave Judge Makhubele the bundle of documents, and what then happened?
After I left the offices of PRASA on the 14th of November 2017, once again, Judge Makhubele and I interacted with each other, and it all culminated, Chairperson, in correspondence, in terms of which an offer to settle was made. And
Can you remember when was that?
that must have been prior to the 15th of December 2017.
I want to refer you to page 53,
I am on page 53.
paragraph 13.
Paragraph 13 on page 53, Chairperson, is an important WhatsApp message that was dispatched to me by Judge Makhubele on the 19th of December 2017 at 1300 hours 44.
Just before you proceed, prior to that dated December 2017 WhatsApp, was there any engagement between 14 November 2017 and 19 December 2017?
By way of WhatsApp and SMSs?
Telephones, calls?
Yes, of course, all of which were downloaded by Mr. Clint Ulerman and his team from the Zondo Commission. So what my approach, Chairperson, was in my response was to direct the Professional and Ethical Committee of the Pretoria Society of Advocates' attention to the most important and the most significant correspondence in answer to the complaint that was laid by Judge Makhubele against me. And that is the complaint that is in the bundle marked BB.
Let's go to paragraph 30 now of page 53.
Chairperson, just allow me to contextualize it.
Okay.
There was an offer made by the attorneys of PRASA, either to Mr. Tsepo Matopo or to Mr. Johan Krause. What they have tendered in the correspondence, Chairperson, was payment of the capital amounts. On all four matters, the capital amounts, may I just emphasize, as it was set out and provided for in the summonses and the particulars of claim under each of these case numbers. Prior to that communication, Chairperson, I was under the impression that PRASA, through my communication with Judge Makhubele, was prepared not only to settle on the capital amounts, but also the interest. And the letter from Mr. Madimpi Mogashue didn't contain interest. Interest, Chairperson, was not provided for. May I add, we were on the same page insofar as costs are concerned, in that each party should be liable for its or her own costs.
Sorry, can we just go back a bit?
Yes, Chairperson.
You were now involved in the arbitration, am I correct? You now before Judge Brunt in the arbitration. Let's go to that point. Who made the offer to settle?
The first offer to settle, a formal offer, was the offer that was made by Mr. Mogashue in his letter. That's the first formal document which indicated in no uncertain terms that PRASA is prepared to pay or to settle the amounts which were claimed by the plaintiffs in the summonses I've already indicated.
And when was that letter received?
Chairperson, that must have been prior to the 15th of December. It was not addressed to me, although it was communicated to me, and why I say it should have been prior to the 15th of December will become relevant within a minute.
Now, let's just get there. The first formal document offering a settlement was by Mr. Mahashua. Is that correct?
That's correct, Chairperson?
But the letter was not addressed to you.
No.
To whom was it addressed, as
It-
far as you know?
Like I've indicated, Chairperson, either to Mr. Tsepo Matopo or to Mr. Johan Krause.
And did they give it to you?
They've directed my attention to it. Yes, may I just to elaborate? They communicated to me that there's an offer to pay the capital in respect of all four the matters. My response, Chairperson, was the following. On my understanding of what was conveyed to me by Judge Makhubele was that PRASA was also willing to pay the interest. And during our discussion, Chairperson, What I did, and I have the document in front of me, this is my original notes that I made in this time period for one good reason. If the plaintiffs reject the formal offer and make a counter offer, they could lose everything. In that PRASA can say, well, you rejected our offer on the capital, you make a counter offer that you are prepared to settle by virtue of capital and interest, we're rejecting it. And then we're back to square one. So what I did is, before I could advise either Mr. Tsepu Matopo or Mr. Krause, in my own limited calculation insofar as accounting is concerned, I took each and every claim on all four these matters, and I then worked out interest at the rate of 9% over a period of 27 months, because at the time it was 27 months since the summonses were issued. And may I, Chairperson, on my calculation, I'm not saying I'm right, the amount concerned, only in interest, was 5,520,057 rand and 27 cents. So what I then did as Chairperson, my advice was, don't reject the offer. Don't take that risk. Rather, address a letter to Mr. Makhubele, a friendly letter, and ask Mr. Makhubele, is your instructions correct? Do we understand it correct that it's only the capital that's been offered or tendered and not the interest? And that is what elicited the WhatsApp by Judge Makhubele.
Let's just, again, go slowly and get it all back to where I started. It appears to me, and please correct me if I'm wrong, that you had private discussions with Judge Makhubele where it was indicated to you that PRASA was willing to settle for interest, for the main amount, plus interest and cost. Is that correct?
Excluding cost. No,
No.
Chairperson. No, definitely not costs.
But claim and interest.
Correct, Chairperson?
Was that before you saw the formal document from Makhubele's attorney?
Yes, Chairperson. Yeah, long before. On my calculation.
Yeah, no, but, and they then, what did they then do?
They then dispatched a letter to Makhubele, not rejecting the tender insofar as the capital is concerned. They didn't want to jeopardize or lose out on that opportunity. They asked, are you sure your instructions are only to tender the capital, excluding the interest?
Did you tell them how they should write the letter?
Definitely, we discussed it, yes, and my advice, Chairperson, was, as I've alluded to, don't do something that we're going to lose out, or the companies are going to lose out, on the capital. I was very much aware that it's a dangerous game to play, to make a counter offer, and they come, or they see it as a counter offer, Mr. Makhubele, it's rejected, and then we've lost out on the opportunity.
So before Mr. Makhubele wrote the letter setting out the terms of settlement, you already knew from your private discussions with Judge Makhubele that they were going to settle.
Yes, 100% correct, Chairperson, and may I add, I communicated that as much to Mr. Matopo and Mr. Krause. I said to them, this matter is becoming ripe for settlement on the basis that I've just alluded to. Yes.
Thank you.
Then, Chairperson, sorry.
Advocate Boetis, I want to refer you to page, do you have volume 8 before you?
Yes, I have.
I want you to refer you to page 272.
272, yes, I'm on 272.
If you look at that letter, it is addressed to Diale Bakhasho attorneys, and it is from Mr. Lindy Kayazide. If you look at page 274, and it's dated the 15th of December 2017. You see that correspondence?
I do.
And then, before I question you about it, if you go 2 pages onto page 276,
Yes,
there is a correspondence dated the 18th of December 2017 to Mr. Makhashwa, and it is from Mr. Matopo.
correct.
Now, let's just start with this 15th of December correspondence. Did you see this correspondence?
May I just go one step back?
Thank you.
If, Chairperson, if I may go back to page 53, paragraph 13. That is what I call the important WhatsApp that I received from Judge Makhubele on the 19th of December 2017 at 1300 hours 44. And it's important to read it into the record. It says, I forwarded the letter to PRASA. Now that letter, Chairperson, is the letter on page 276 in volume 8, with instructions to inquire from Mokhashua if he received this and to forward same ASAP. Our instructions were transparent, hence I forwarded the copy to you. The intention was to have an open discussion with you and your attorneys, but due to your unavailability, we instructed him to engage your clients. I think the correctness of the calculation of interest will be verified by PRASA Finance. The principle is acceptable, and those were the instructions. Regards, Nana. That's Annexure C. Chairperson, it's important for this commission to take cognizance of the fact that the letter that I was just referred to in volume 8, page 272, was attached to this WhatsApp. That is the same letter, Chairperson, which appears as an annexure to my response, marked Annexure D for David. That should be, Chairperson, if my pagination is correct, on page 83 of this bundle. This was the first time when it came to my attention that the instructions from PRASA, as on the 15th of December 2017, was to include the interest added or calculated to the capital amounts. May I take it a step further, Chairperson? Sorry. Page 272. Yes, page 276. I apologize.
I will repeat, sorry, I didn't have my mic on. Now let us refer to the letter of 18 December 2017 which is addressed to Mr. Makhashwa. You see that one?
Yes, I do. I have it in front of me.
You've indicated that you did consult with Mr. Matopo with regards to what to respond to.
That's correct.
Is this the correspondence that you talk about whereby you indicated or you assisted with the drafting of the letter?
That's correct. I can see my hand in this letter, yes.
Okay. Sorry, what did you want to add? I interrupted you. I just wanted to ensure.
No,
this.
that's fine. No, that's fine.
Okay. So now this correspondence of 15 December 2017, which is from Mr. Lindy Kaya Zide, who is the group company secretary at PRASA, is addressed to Diale Makhashwa, who's representing PRASA. You say this was brought to your attention.
That's correct, by virtue of the WhatsApp alluded to and described in paragraphs 13 and 14 of my response on pages 53 and 54.
Did you bring this correspondence to the attention of Mr. Matopo and Mr. Kraus?
Immediately. And that is why, Chairperson, you will find paragraph 3 on page 277. That's part of the letter dated the 18th of December 2017, where Mr. Matopo says, your client, PRASA, did not, and not is emphasized, instruct you to submit an offer or tender to our clients in respect of the capital amounts only. Your client's specific and express instruction to you was to submit an offer or tender to our clients, which provides for payment of interest ad tempore mori at a rate of 9% per annum, calculated from the date/s upon which the respective summonses were served on your clients.
Can we just pause there for a minute?
Yes, Chairperson.
This information that is referred to in the letter, your client, PRASA, did not instruct you to submit an offer or tender to our client in respect of the capital amounts only. Where did Mr. Matopa get that from?
From Annexure D, that's the letter dated the 15th of December 27, Chairperson, pages 83, 84, and 85.
No. The information I'm concerned with, your client, PRASA, did not instruct you to submit an offer or tender to our clients in respect of the capital amount only. Where did Mr. Matopa get the information from that PRASA was willing to settle for capital and interest?
From me, Chairperson.
I see.
From me, Chairperson.
Yes, thank
And
you.
that is what I wanted to add. May I just allow me 1 second? I have in my possession, Chairperson, a copy of that very specific Annexure D. That's PRASA's letter addressed to Mr. Makhashwa, dated 15 December 2017. This is a hard paper. It's not paper that we use in the printing facilities at the bar. It seems to be, it's not an original, but it's printed in color, if I may just direct your attention to this document. This document I found, Chairperson, either in the pigeonholes of the chambers, of our chambers, or it was left at my door shortly before the letter by Mr. Matopo was addressed to Mr. Makhashwa.
And when you say letter addressed to Mr. Makhashwa, which letter are you referring to?
D, that's the letter in volume 8 from pages 272 until 274. That's the same document that's attached to my response, marked Annexure D for David from pages 83 to 85. And so the matters became settled.
Before you continue. These amounts are contained here. That's okay. I want to refer you to page, I'm going to ask you that you use volume 8,
Yes.
page 273.
Yes.
And same volume, page 277.
Yes.
Right. Now, these are the two letters that we are dealing with, the one of 15th December 2017 to Mr. Makhashwa from the company secretary Prasa, and the second letter is the one that Mr. Matopo addresses on the 18th of December to Mr. Makhashwa. You see that?
Correct.
Right. Let's start off with, we will do a comparison. If you look at paragraph 2.1 of the letter to Mr. Makhashwa, the one dated the 18th of December, it says case number 47598 of 2016. You see that?
I see that.
And the amount there is 15 million and 300 and something odd rands. You see that? 15 million rands. For case number 47598 of 2016, it refers to an amount of 15 million. You see that?
I see that.
And if you go back to the letter on page 273 and you look at paragraph 2.5, the amount is exactly the amount that was claimed. You see that?
Chairperson, just to avoid any confusion, on page 273, the amount which appears on paragraph 2.5 is exactly the amount which appears on page 277 in paragraph 2.1. And
similarly, the amount on paragraph 2.2 of page 277 with regards to case number 73933 of 2015 of 8 million is exactly the same as that appears in paragraph 2.4 on page 273.
That's correct.
And paragraph 2.3 on page 277, 73934.
No, it's not 73, it's 7098481,65. And that corresponds with 2.3 on page 273, exactly the same amount.
Yes, but I'm saying it's case number 73934 of 2015 that gives you that 7 million rands.
My apologies. Yes, that's correct.
Thank you. And then 2.4, case number 47597 of 2016. Sorry, wait. It's 5 times 7. It amounts to, it's in paragraph 2.6. The settled amount being 19 million. You see that?
Yeah, exactly
on
the same
page
amount.
273.
Chairperson, paragraph 2.6 on page 273 is exactly the same amount, which appears in paragraph 2.4 on page 277. I confirm that.
Now, these amounts here, were you, did they include interest or did they not include interest?
It excluded interest, Chairperson.
And who indicated that the interest must be included?
It's evident from the document on page 272, that's the letter dated 15 December 2017, that interest should be added. It's said in more than one paragraph, if my recollection is correct. More specifically, on page 274, paragraph 292, attorneys representing CIRL Solutions in the total of 19,583, 778,42 plus interest, as well as 2.9.1.
Thank you.
So just for the sake of clarity and completeness, the interest, Chairperson, is addressed in the letter dated 15 December 2017 on page 273. Page 273, Chairperson, the second paragraph from the foot of the page under the heading capital letter C, interest payable. It says, it was noted that in some instances in the summons instituted, the interest claim was to be reconned from the date of invoice. The instruction to you is that the payment of interest should be reconned from the date of summons. And then if you turn the page, there's the full and final offer. You are instructed to tender this offer as follows. And there it's set out in clarity the capital amounts as claimed plus interest.
Thank you. What then happened?
Thank you, Chairperson. On the 21st of December, 21 December 2017, formal tenders were submitted by Diale Makhubele attorneys in accordance with the provisions of Rule 34, bracket 1 of the Uniform Rules of the High Court, which reflected exactly, Chairperson, what is contained and provided for in Prasa's letter 15, December 2017, in volume 8, pages 272 and 274.
I want to refer you to volume 8 to page 281 and right through to page 285.
Chairperson, these are the settlement offers which were submitted by the Ale Mokhashua attorneys dated 21 December 2017.
And you had sight of these settlement offers?
Yes, I did.
Okay. Were you in agreement to what now was contained as per the amounts contained on page 281 to 285?
I verified it. I was satisfied.
What then happened?
I took it upon myself and I volunteered to prepare draft awards. I emphasize the word draft awards, Chairperson, in accordance with what is contained and provided for in these settlement offers. I prepared them myself, and those are to be found, Chairperson, in the documents, not volume 8, the document that I have in front of me, which contains my response. That's Annexures E for Eddie on page 86, right until Annexure H for House. So, once again, Chairperson, the methodology that I adopted was in the heading Private Arbitration, quorum the Honourable Retired Judge F. D.J. Brunt, and in each of these matters, I then prepared 4 draft awards. It was communicated to Judge Brunt that the matters became settled it's not necessary for him to concern himself over the arbitration, as it is not necessary to continue therewith or with the arbitration. Either Mr. Matopo or Mr. Krause then disseminated the awards to Judge Brandt electronically. He indicated to us, Chairperson, or indicated to the attorneys, that he received the awards, that he insisted that I, together with Mr. Mokhashue, appear before him specifically to confirm, one, that all four of these matters became settled, and two, that the matters became settled in accordance with Mr. Mokhashue's instructions from PRASA. Judge Brandt was in Pretoria. He was presiding over another matter at the offices of Adams and Adams attorneys. The offices are situated in Linwood Bridge and Davinish Lane. Judge Brandt indicated to Mr. Mokhashue and I that he is available on the 7th of February 2019 at the offices of Adams and Adams, and he invited us to provide him with the draft awards so as to afford him an opportunity to consider it and to hear both of us thereon. I asked my secretary to remove the word draft from the heading, but rather to provide for just the word award. And I attended at the offices of Adams and Adams together with Mr. Mokhashue on the 7th of February 2018, and we presented Judge Brandt with these awards. Judge Brandt didn't merely proceed to rubber stamp it and to sign it. He was not satisfied with the interest as provided for in each and every of these awards contained in and provided for in paragraph 2, Chairperson. Judge Brandt then took his pen and he deleted 22 December 2018. 22 December 2017, and he then inserted in his own handwriting in manuscript 16 January 2018. He signed it, that amendment. He also signed each and every of these awards and provided me with the originals. Upon my arrival at Chambers, I invited a representative of either Mr. Matopu's office or Mr. Krause's office to meet me at my chambers and to provide them with the original awards. I didn't keep the original awards in my office. On that basis, Chairperson, everybody concerned, Mr. Mokhashue included, and he confirmed it in so many words to Judge Brandt, according to his express instructions from PRASA, all four these matters became settled in accordance with his express instructions. Payment was, however, not forthcoming. And there were correspondence and numerous discussions between Judge Makhubele and I. The reason being, Chairperson, the liquidators and the attorneys phoned me and said to me, well, you managed to settle all of these matters. It's wonderful, but when can we expect payment? Payment is not forthcoming, notwithstanding the fact that these awards were made on the 7th of February 2018. 18. And it was evident, Chairperson, that somewhere, somehow, there was a problem insofar as payment is concerned. And I then advised Messrs. Matopu and Krause to initiate 4 applications to the High Court in accordance with the provisions of Section 31 of the Arbitration Act, so as to make the awards orders of the court. I was instructed to prepare the 4 applications, which I did. I'm the author of all four of the applications. All 4 the applications, Chairperson, were served or delivered at the offices of Diale Makhubele, and no notice of intention to oppose was forthcoming. To me, it wasn't a surprise, as the matters became settled in accordance with Mr. Makhubele's instructions.
Just before you proceed, Advocate Boetes, you've indicated that the 4 awards that had been made by Judge Brandt, they were given to Matopo and to Mr. Krause, the liquidators. Anyone else given these 4 awards by Judge Brandt? Besides Diale, did you give them to anyone else? So there were 3 people you gave them to: Diale, Makhubele, and Krause. Anyone else?
Just a correction, neither Mr. Matopo or Mr. Krause were the liquidators. Liquidators were Tshwane
okay.
Trust, Mr. Hannes Miller et al. Mr. Matopo and Mrs. Matopo and Krause were the attorneys representing the entity which was not liquidated, that's called CIA Rail Solutions, as well as the liquidators. So the liquidators appointed attorneys to represent them in these proceedings, as three of these matters relates to the insolvent company CIA DB Consulting Engineers, and the other entity was CIA Rail Solutions Pty Limited, which was not wound up. So to answer your question, I gave it to nobody else. I provided Judge Brandt, or the attorneys provided Judge Brandt via email well before the 7th of February with the draft awards for everybody to consider. But on the 7th of February, I had the original signed by Judge Brandt as amended, which I then provided or handed over to a representative. I can't recall whether it was from the office of Mr. Matopo or whether it was from the office of Mr. Krause. And my comment was, keep this in safe keeping. It's a lot of money, a lot of effort went into it, and it's in the best interest, definitely, of the creditors of the insolvent companies that effect should be given to the awards.
Did you ever inform Judge Makhubele of the awards?
I can't remember if I expressly conveyed to her that we were successful in that Judge Brandt made the awards. Subsequently, yes, definitely, that was the subject matter of various conversations as a result of the fact that payment was not forthcoming. So everybody concerned, including Judge Makhubele, was aware of the fact that the awards were made by Judge Brandt on the 7th of February 2018.
Okay. Let's take it from the stance that there is no payment with regards to these awards. You then prepared the 4 applications and you were served on Diale Makhasha, and there was no notice of intention to defend. You
No,
said,
notice of intention to oppose.
to oppose, sorry. And you said you were not surprised. What then happened?
All 4 matters, Chairperson, was set down in the unopposed motion court roll in the High Court in Pretoria on Friday, the 9th of March, 2018. The practice in our division, where I practice from, is even if there's a notice of intention to oppose, but no opposing affidavits are forthcoming, the matters or the application remains on the unopposed motion court roll. It's within the presiding judge's discretion how to deal with it. So as these matters were not opposed, it was set down for hearing. 4 matters in 2 courts, Chairperson. The matters under case number 73934 of 2015, 73934, and case number 47598. I repeat, 47598 of 2016. They were enrolled for hearing in Court 2A, A for Abram, before the Honourable Acting Justice Holland Muter. They were respectively numbers 29 and 23 on page 4 of his roll. The other 2 applications, Chairperson, that's case numbers 73933 of 2015, I repeat, 73933 of 2015, and 47597 of 2016. They were set down for hearing in Court 2B for Benny before the Honourable Mr. Acting Justice Peterson, as he then was. And it was respectively enrolled as number 69 and 64 on page 4. Set down for hearing, Chairperson, Friday, the 9th of March, 2018. All of a sudden, out of the blue, on Tuesday, the 6th of March, 2018, whilst Mr. Mokhashue was still on record, 4 notices of intention to oppose were delivered at the offices of the applicants as instructing attorneys. Matopa and Krause, yes. That was on Tuesday, the 6th of March, 2018. And Prasa was, or did, purportedly instructed Bauman Gilfillan Incorporated to file and deliver these notices of intention to oppose. Chairperson, my immediate reaction was that those notices constituted an irregular step, as Mr. Mokhashua was still on record. That was communicated in correspondence by Mr. Matopo, and that led to Mr. Mokhashue's withdrawal as attorney on behalf of Prasa, which notice, Chairperson, was filed a day before the hearing on Thursday, the 8th of March, 2018. In the light of this developments, Chairperson, I entered into an engagement with both Mr. Matopo and Mr. Krause. And the reason being, I was concerned whether or not Mrs. Bauman Gilfillan Incorporated had a mandate from Prasa to oppose these applications. And may I add, if it was normal circumstances and I arrive at unopposed motion court and somebody attends motion court and say, well, we're late, but here we are, our instructions are to oppose the application, here's our notice of intention to oppose, my immediate reaction, Chairperson, would be allow them. That's the right thing to do. As a result of the history of this matter, I suggested to Mr. Matopu and to Mr. Krause, why don't you deliver a notice in terms of Rule 7(1) of the Uniform Rules of the High Court and call for Mrs. Baumann-Gilfillan to present you with a mandate, with a resolution, so as to satisfy yourself that PRASA did indeed provide such an instruction. Let's rather err on the side of caution. That was my approach. And on the same day, Chairperson, 4 such notices were filed and delivered at the offices of Baumann-Gilfillan Incorporated. And upon my arrival, sorry, Chairperson, I thought you were still writing. Upon my arrival at court, I was there because it was a substantial amount of money at stake. It was important for my clients that I attend unopposed motion court. I asked my opponent in so many words, colleague, can you present me with a mandate, a resolution adopted by PRASA's board that these applications are indeed opposed, in the light of what transpired before Judge Brandt, etc. My opponent wasn't in a position to provide me with any such resolution. As the 4 applications were set down in 2 different courts, Court 2A and Court B, I approached my colleague and I said to him, don't you think it's conducive that all 4 applications be heard before one judge? You make your submissions, I make your submissions. I think that's the correct approach. He agreed with me. Both of us went to Court 2B before acting Judge Peterson. We indicated to him what the status of the matters at the time was and what transpired, and he was quite comfortable, my lord, for Chairperson, for the, I apologize, for the two applications which were set down before him in his court to be removed and to be taken to the so-called senior court 2A, so that it can be dealt with simultaneously.
Yes, proceed.
What is important, Chairperson, is for me to be 100% satisfied that we're doing the right thing here, that the matters are not opposed. And that is where the SMS, not WhatsApp, SMS communication came about between Judge Makhubele and I. A proper reflection of which is contained in Judge Makhubele's complaint against me in paragraph 33. Chairperson, just allow me to go. I apologize. No, let me just find the correct. Yes. Page 19. Yes, that's indeed so, Chairperson. Thank you, Chairperson. After the notices of intention to oppose were filed, I immediately engaged by way of SMS with Judge Makhubele so as to understand exactly what was transpired, what transpired. And Chairperson, you will note from the bold under 33, where it says, where Judge Makhubele says, our SMS exchange went as follows. Boetes at 600 hours 32 a.m. I wrote to Judge Makhubele via SMS, Dear Nana, I trust that you are well. Did PRASA decide to oppose the 4 applications that were initiated by virtue of the awards made by Judge Brandt? ? Kind regards, Francois Boetes. Judge Makhubele then answered as follows, Chairperson. She says, Morning, Francois. Nothing has been brought to my attention. I am boarding a flight now to Cape Town to meet the Deputy Minister of Transport about my imminent departure. I will also meet the Minister of Justice to discuss the controversies raised at Unite Behind, echoing the sentiments of legal section. They have already written to CJ, that's the Chief Justice, President and the JSC. My involvement in the settlement of this matter is cited amongst reasons why I should be investigated by the JSC. As you can imagine, my priority now is to get all this cleared up so I can continue with my judicial duties. I'll talk to you when I return. Regards, Nana. My response, Chairperson, is to be found in the next WhatsApp at 822. That's at the foot of page 19 of volume 19. I said, what I did is, I sent screenshots to Judge Makhubele of all 4 the notices to oppose, which were filed by Bauman Gilfillan Incorporated, with the 4 different case numbers. I took screenshots of those notices to avoid any confusion or uncertainty. And at 1000 hours 02, 1000 hours 02, Chairperson, you'll find the message at the top of page 20 of volume 19, where it refers to Judge Makhubele. These are her words. Just landed in Cape Town. Now the important part comes in. Those attorneys have no authority. PRASA legal panel has been suspended since 1 December 2017. We are using SAC AAA panel. I know they couldn't have been appointed through that panel. Only those who had instructions already continue. I have just asked Zide. He says decision was taken by Martha Ngoye and the current AG CEO. I am about to start meetings. Full stop. And my response was short, Chairperson, as you can see. Thank you, Nana. And this, Chairperson, is where the controversy emerged from. This message. And allow me to explain to you why I say so. When Judge Holland-Muter dealt with all these unopposed matters, these 4 matters stood down as they were opposed, and I addressed Judge Holland-Muter, and I conveyed to him what I've just alluded to within this commission. And I said to Judge Holland-Muter, my lord, on all 4 of these files, you'll have notices in terms of Rule 7.1 of the Uniform Rules of the High Court. I asked my learned colleague whether he is in possession of any written mandate, resolution, some form of authority. And I can take you into my confidence, my lord. He doesn't have. He doesn't have. And in addition, I, as an officer of the court, have the confidence to submit to you that I'm in possession of an SMS of the chairperson of PRASA, in which the Honourable Judge Makhubele confirms those attorneys, referring to Bowman Gilfillan Incorporated, have no authority. Judge Holland-Muter accepted my address, my submission to him. And he said to my colleague, but in the light of what Mr. Boertes just conveyed to me, I mean, how on earth can you persuade me that you have a mandate or you have authority from PRASA to oppose these applications? No answer was forthcoming. I prepared 4 draft orders. Judge Holland-Muter asked me, the 2 matters which you brought the files from Court 2B, are these similar? I said to Judge Holland-Muter, copy and paste. Just the amounts differ. Differs. Bar from that, everything is exactly the same. I'm comfortable. I'm satisfied proper cases have been made out. I prepared 4 draft orders, which I handed up to Judge Holland-Muter, and he was satisfied, and he consequently made all 4 draft orders of the High Court. Not that I'm aware of, no. That largely, Chairperson, was the end of my involvement. The reason being, I became involved in matters in other jurisdictions, in other courts, which were already set down. All that I know, Chairperson, is that correspondence were exchanged from various public organizations, I think at Unite Behind and other organizations, where allegations were made of serious nature. I wasn't involved in it. And then an urgent application was initiated. Because, Chairperson, as a result of those orders, Messrs. Matopo and Krause prepared writs to execute. The writs were issued by the registrar of the court, and then it was presented to the sheriff of Pretoria East. I forgot her name now. The sheriff then attached to the monies held in PRASA's bank account, in the line of all these capital amounts, which were made orders of court. And then, Chairperson, an urgent application was then initiated to prevent the sheriff from paying those funds to the liquidators or to the attorneys. The way I understood the relief which they applied for is for the operation of those writs to be suspended pending the institution of subsequent applications. Like I've said, Chairperson, I haven't read those applications. I were not available. As a matter of fact, Chairperson, I wasn't even in Pretoria. What my advice is irrelevant. What I do know is that there were opposing affidavits filed, but orders were given. I don't know which court, which judge. I just learned orders were given to the effect, Chairperson, that the monies were kept safely in the trust account of the sheriff.
Chairperson, I see it is nearly 1:10. We're going to ask for the lunch adjournment until 12.
No problem, Chair.
Yes, you still reminded you're under oath. Mzungu.
Thank you, Chairperson. Advocate Boetes, you've indicated that, or it is on evidence that your response was in regards to the Professional and Ethics Committee. You remember that?
That's correct, Chairperson.
Did you receive any outcome in regards to that complaint that Judge Makhubele laid against you?
I did, Chairperson.
I want you to refer to page 99 of volume 19.
I have it in front of me, Chairperson.
What was the response that was provided to you?
Chairperson, the Professional Ethical Committee of the Pretoria Society of Advocates appointed 3 experienced sulks to consider the complaint, and on the 22nd of May 2020, I received a letter on behalf of the Pretoria Society of Advocates. The author is the General Manager. The letter is addressed to me, and it refers to the complaint lodged against you by the Honourable Madam Justice Makhubele, and it reads, the Professional and Ethics Committee of Pretoria Bar investigated the above complaint and resolved that there was no merit in the charges brought against you by Makhubele J, and accordingly that no further steps are to be taken.
Thank you.
Sorry, were you present at a hearing of the Society of Advocates?
Chairperson, no, there was no hearing. The process in our society is as follows. There's first a preliminary investigation by the Professional and Ethical Committee. If the finding of that committee is that there is a case to be answered, it is then referred to the disciplinary committee. The disciplinary committee chairperson will then appoint a prosecutor and a committee, and then a physical hearing will ensue.
The composition of those 3 silks you're referring to, was it counsel from Pretoria Bar only, or a combination of 1 or 2 from the Johannesburg Society, as it always sometimes happens?
Chairperson,
It was all from Pretoria.
I can't recall who the 3rd person was, but I know for a fact that the 2 that were appointed, I haven't communicated with them. I just heard in the grapevine, definitely 2 were members of the Pretoria Society of Advocates.
2 of them.
Yes, insofar as I could recall. Yes, Chairperson.
Okay, thank you. Advocate Zungu.
Wait, sorry. Could you just give us a synopsis of what the complaint was?
Chairperson, I think to summarize it, may I direct your attention to 1 paragraph in the complaint, and that is how I understood the complaint to be. And I apologize once again, my papers are not properly indexed and paginated as you have it, but it's to be found in paragraph 97 of the complaint, 97. Now, whilst Chairperson turns to paragraph 97, that's on page 34 of the complaint. Judge Makhubele, in a complaint, sets out the history insofar as she was involved in, not only in respect of my involvement, but from a general perspective, from a general background. And then she makes the following allegation or submission in paragraph 97. She says, I believe that the explanation of Boetes SC and his instructing attorney Matopu about the reasons for their conduct will restore my dignity, integrity, and reputation. And in conclusion, Judge Makhubele, and this is where the complaint, it seems, that's the high watermark. She submits, I request an investigation with regard to the conduct of Botus SC, A, in relation to the SMS exchange between us, why he shared it with his instructing attorney, Tsepu Matopo, who then passed it off as communication between me and him in his letter addressed to Bauman Gilfillan attorneys. B, in relation to the alleged submissions made by Botus SC before Holland Muter J on or about 8 March 2018 in the matter between PRASA and the liquidators of Siyaya companies in liquidation, wherein he relied on our SMS exchanges converted into a letter. And lastly, C, in relation to allegations in Mrs. Ngoye's affidavit that when making submissions before Holland Muter AJ, that's correct, he was Holland Muter AJ at the time, he disclosed the contents of a letter written with prejudice from PRASA's attorneys or PRASA with regard to settlement proposals. So this is how I perceive the chairperson, just in respect of paragraph C. That letter was not from PRASA's attorneys, it was Mr. Matopu's letter, which was marked with prejudice of rights. That's how I understand it, chairperson.
What's the complaint?
It seems that Judge Makhubele is aggrieved that I disclosed the communication between us to Mr. Matopu, that I discussed it not only to Mr. Matopu, but also Mr. Krause. And it is so, she's 100% correct. That SMS found its way to a letter that was addressed to Bauman Gilfillan Incorporated, marked with prejudice of rights. And if one contextualize Judge Makhubele's complaint, it seems, and just allow me, chairperson, where she says, she refers to the SMS exchanges, and it seems that when one reads paragraphs 47 and 48 thereof, it gives one a clearer understanding of the environment in which Judge Makhubele found herself. Because she says in this document, in paragraph 47, she says, I was under extreme psychological pressure at the time because Unite Behind was trying to block me from assuming my judicial, as they alleged I had breached the code of conduct of judges by agreeing to serve in the PRASA board. And then I leave a portion out, chairperson, in paragraph 48. Judge Makhubele says, Botus SC knew the pressures that I was being subjected to at the time. He knew my frustrations. He persisted to involve me in the matter. When I first answered the SMS inquiry on the fateful day, it was clear that I did not want to get involved. He persisted and forwarded the screenshots of the notices to oppose, and then I broke down and responded the way I did. I was vulnerable, and someone elicited my responses that were later used against PRASA. To summarize, chairperson, that is how I understand the complaint.
May I continue, Chair? Thank you. You also indicated that you had to hand over your cell phone and your iPad for analysis. Is that correct?
That's indeed correct, chairperson.
And did you ever receive any reports in regards to the information that had been downloaded? Did you ever receive the reports?
No, I never received a formal report, not at all. Mr. Clint Ulerman did correspond with me telephonically, and I asked him in one of our discussions, are you satisfied that you managed to copy and paste, or chairperson, the word I used was to clone my iPad and my cell phone? And he said, yes, thank you very much.
So I just want to ask you, and I want you to refer to this report and indicate whether you've ever seen this report. I wanted to page to volume 19. Volume 19, page 174.
174.
Yes.
No, chairperson. I haven't seen this document.
Have you never seen this document?
Chairperson, no. I have seen the portions of the transcription of the insolvency inquiry, because I had a whole copy of the transcript with me. Mr. Clint Ulerman, chairperson, did inform me that if one compares my cellular telephone records and Judge Makhubele's cellular telephone records, it seems that the first call was made from my cell phone to her cell phone, and not vice versa. And he said to me, is there any possible explanation? I said to him, Mr. Ulerman, first of all, I was totally unaware of the fact that Judge Makhubele was at PRASA and that she was deployed there. It might as well, I can't recall, that the call was made from a landline. If it doesn't appear on the records of her cellular telephone, I don't have an explanation for that.
But what's your evidence?
That is my evidence, chairperson, that Judge Makhubele, in the first or the second week of November 2017, approached me on my phone by virtue of a phone call, and that is the way it played itself out is recorded in my response to the complaint, which was investigated by the Professional and Ethical Committee.
Thank you, Chairperson. I have no further questions.
Thank you. Mr. Maluleka?
It's Maleka, Chair.
Yeah, Mr. Maleka.
Mr. Botes, can I just make sure that when I ask you questions and you answer, we speak about the same person? You referred to Mr. Tsatsawane. Can I place his proper names and surnames on record? It is Mr. Kennedy, Kennedy, Tsatsawane, Tsawane, SC. Is that the same person you referenced in your evidence in chief?
That is correct, Chairperson. I apologize if I pronounced Senior Counsel's surname wrongly. It wasn't with any intention or with any motive.
No, I understand. And certainly I'm not suggesting that you are disrespectful of him. I just want to make sure that we speak about the same person.
That's indeed so, Chairperson.
You were referred to the report at page 174 of volume 19. I understand this report to be a product of forensic analysis by the investigator appointed by the Zondo Commission, Mr. Gautier. You'll see his name at page 175. Do you see that?
I do, Chairperson.
And I assume that you are familiar with this name, Mr. Coutier.
Not at all,
Not at
Chairperson.
all.
I've never met him. I don't know who he is.
Yes.
If he was indeed part of the team who attended to the chambers of Advocate Johan Hershenson, who made his chambers available for the transfer of information from my cellular telephone and my iPad, there were more than one person, there were a team.
Yes.
Whether he was part of the team, Chairperson, no, I don't know.
Yes.
I wasn't there, I wasn't present when it was done. I was expressly asked
Yes.
to remain in my chambers.
Yes. For the purposes of this inquiry, we rely on documentation furnished to us, including this report. On the face of it, this report suggests that it's a product of a forensic investigation of your electronic gadgets and that of Judge Makhubele.
I accept that, Chairperson.
And the principal purpose of that forensic investigation was to establish, as between you and Judge Makhubele, who originated the communication of the first instance. I wonder whether you would be able to confirm that that was the purpose of the investigation, or would you like to read the report for yourself before you express a view in that regard?
I accept your word, Chairperson.
Yes. And based on that purpose of investigation, Mr. Coutier expressed some conclusion at page 180. And you'll see he begins to formulate his conclusion in the preamble of paragraph 19. I wonder whether you're there.
I saw that, Chairperson, and I've read it.
Yes. And I assume that based on his own investigation, that's the conclusion that you have seen, and I wonder whether you would take issue with it at this stage.
Chairperson, no. If you will allow me, in paragraph 19.1 on page 180, whilst you asked me the question, I read through it. According to this document, the call was 57 seconds in duration. The first call between Judge Makhubele and I was definitely not 57 seconds. It was a lengthy call because I congratulated her upon her recommendation and we had a very, very cordial discussion. Definitely not 57 seconds.
Yes, now I understand that, but I'm saying from this report, it appears as if you originated the contact.
I accept that, Chairperson.
Yes. I'm not suggesting anything more than that.
No, I accept
Yes,
that.
yes.
Mr. Malik, I accept that.
You also referred to a conclusion expressed by the Ethics Committee of the Pretoria Society of Advocates following upon the complaint that Justice Makhubele lodged against you. You remember that? That's the letter of 22nd of May that you received.
Chairperson, just allow me.
Yes.
I don't know whether there was a written report submitted to Bar Council. I don't know whether the Professional Ethical Committee did in fact prepare a report. The only communication that I received was the letter dated 22 May,
Yes.
which I've alluded to. But apart from that, Chairperson, I didn't receive any communication whatsoever from the Professional Ethical Committee, and that's the reason why I don't know the third person who is on the panel.
Yes. And if you don't mind, if I may ask you to go to the letter of the 22nd of May, which is at page 99 of volume 19.
I have it in front of me, Chairperson.
Yes. And before I ask you to assist us about that letter, may I ask you this? You are described as F.W. Bottas SC. For our own edification. When did you take silk?
I received my latest patent from the President of the Republic of South Africa on the 22nd of September 2014.
So by this time you would have practiced as a silk for about
5.5 years. Give or
6
take 6 years.
give or take 6 years.
I accept that, Chairperson.
Yes. And you would have been, in colloquial terms, have been a silk of some reasonable standing at the bar.
I accept that, Chairperson.
Yes. And what this letter does is to say that your conduct based on the complaint by Judge Makhubele and your response, you have not conducted yourself in any unethical way, correct?
That's how I understand it, Chairperson.
Even when you communicated with Judge Makhubele in the course of your discussion around the CCIR matter,
That's how I understand it, Chairperson.
even when you disclosed your communication between you and Judge Makhubele to your instructing attorneys, Matopo and Krause attorneys,
That's how I understand it, Chairperson.
and even when you disclose the SMSs to Judge Holland Mutter for the purposes of exercising his judicial powers on the application to confirm the arbitration awards as court orders.
That's correct, Chairperson. The manner in which that was disclosed to, the letter that was addressed to Bauman Gilfillan Incorporated by Mr. Matopo, marked with prejudice of rights, was filed a day or two on the court file, on the court file subsequent to the hearing.
Yes. And you will see that this finding by the Pretoria Bar Council vindicating your ethical conduct, it is dated 20 May 2020. Do you see that?
It's incorrect, Chairman. It's dated the 22nd of May 2020 and it's addressed to me.
My apologies. The 22nd of May. Really apologize.
I accept that, Chairperson.
I'd like you to go to a document which is in volume 8, just for you to place a marker on a date, because that date is going to become important in the light of page 99 of volume 19.
I have it in front of me, Chairperson.
Volume 8, it is the affidavit of Ms. Ngoye. It begins at page 10. And as I have it, it was executed around the 3rd of April 2018. Do you see that? At page 50 of the same volume.
That's correct, Chairperson. That's what appears on page 50,
Yes.
volume.
Please bear in mind the date going forward, the date of 3rd April 2018. Because this is an affidavit which was filed by Ms. Ngoye in support of an urgent application to firstly interdict the arrest and possibly use of process funds which were in the hands of the sheriff at the time, with a view to get to Part B, which was the rescission of the orders made by Judge Holland Mutter.
I accept that, Chairperson.
I know that you're not involved in those proceedings, as you indicated, but for now, the limited purposes of my reference is to mark out for you and your attention the date of 3rd April 2018. We now know that as a result of the allegations made in that affidavit, Judge Tuchten gave a judgment wherein she made a number of findings concerning Judge Makhubele.
Sorry, Chairperson, I didn't follow. Sorry.
My apologies. Let me try again.
Sorry, Chairperson.
Let me try again, and my apologies. I have referred you to that affidavit of Ms. Ngoye, and we know that it was made in support of the application before Judge Tuchten. And based on what was said in that affidavit, Judge Tuchten gave a judgment in which she made a number of findings and remarks about Judge Makhubele.
That's Judge Neil Tuchten. It's not a she, it's a he.
Yes, he made a number of findings about and concerning Judge Makhubele. And I assume that you read the judgment.
I haven't read the judgment, no. I'm aware of the judgment, Chairperson. I haven't read it. I don't think it's been reported. I haven't seen it maybe it's coincidence. I was the day in Judge Tuchten's court with another matter when judgment was handed down, the written judgment. But I don't know what it comprises of.
I'm sorry, I rely on instructions of Judge Makhubele, and she has instructed me that she got that judgment from you, and you will see when you read her complaint against you. She does make the point that she asked you for, and you gave her a copy of the judgment.
That's correct, Chairperson. She did ask me to obtain a copy of the judgment, which I did. I don't know whether I obtained it from one of the junior counsel who were in court, the same court that I was in when judgment was handed down. In other words, the junior who noted the judgment, but 100% correct. I got a copy thereof. I did provide it to Judge Makhubele. I didn't study it, no.
Yes. Can I ask you to go to page 35 of volume 19?
I've got it in front of me, Chairperson.
And if you go to page 35, paragraph 83,
Yes.
you will see that in that paragraph, Judge Makhubele made the following point. I contacted Bottas SC immediately after I was alerted to a radio interview and inquired, amongst other things, why the matter was still in the court roll and what actually happened. Initially, he told me that he was sitting in court and that the issues dealt with in the radio interviews were not conversed in open court. The order was obtained on an unopposed basis. He later forwarded me Tuchten J's written judgment, which he said he was shocked about it. Do you see that?
I see that, Chairperson.
And that seems to me to be a matter which is common cause between you and Judge Makhubele's version of events about how this judgment came to your attention.
Yes, that is so, Chairperson. Just allow me to elaborate. The judgment was handed down by the Honourable Mr. Justice Tuchten in court. Members of the press were present at the time. I learned from colleagues and from the press that unfavourable remarks were made by Judge Tuchten in his judgment. Exactly and verbatim what they were, I didn't know. But yes, that is correct.
Yes, I understand. Ms. Ngoye came to testify here, and she confirmed that the application made and ultimately heard by Judge Tuchten was not served on Judge Makhubele, despite the fact that her affidavit in support of that application made serious allegation against Judge Makhubele. I wonder whether you are aware that she was not cited and served with that application.
I was totally unaware of it, Chairperson. May I add, there's a judgment by His Lordship Mr. Justice Tuchten that I rely upon in a large number of matters, the Vodacom and Gogga Technologies judgment, where His Lordship Mr. Justice Tuchten emphasized the importance of service, and the importance not only of service, but that the application comes to the attention to the right people concerned. Just allow me, because that urgent application had to do with relief, which the applicant sought against one of the parties that I don't want to reveal now, it's not important. And then he inquired from counsel whether the application was properly served and whether counsel was satisfied that proper service was effected. Counsel said yes, and the presiding judge was satisfied, and he took counsel's word, and the order was granted. And literally a couple of hours thereafter, an application was initiated in accordance with the provisions of Rule 612C for the reconsideration, because it was in urgent court, and then the respondent submitted and proved, may I add, that the service that the applicants relied upon was a facsimile document. That telephone number which appeared there was a telephone number of some of the applicants and definitely not the respondent.
Yes. Thank you for that. But we don't even need a judgment of Judge Tuchten about service. It's a fundamental rule of law, if not in our modern day of constitutionalism, that you must notify a person against whom you make allegations about them so that they have a fair, reasonable, and prior opportunity to respond to those allegations.
I can't agree with you more, Chairperson.
Yes. Now, we are still at page 35, paragraph 83. And you say, and I'm reading the last sentence, and I invite you to comment on it. He later forwarded me Tuchten's written judgment, which he said he was shocked about. Do you see that?
I see that, Chairperson.
And we have now established that this part of Judge Makhubele's version is in line with yours. What shocked you about the judgment?
Chairperson, when I engaged with Judge Makhubele at this point, she was extremely disappointed. She was upset. She said to me in so many words that observations or findings were made against her which are tantamount to dishonesty or to unethical conduct. And of course I was shocked when I learned it. In my view, Chairperson, and in my eyes, Judge Makhubele was a judge of the High Court. And if somebody, even when I preside in an acting capacity and somebody makes allegations which relates to impropriety or dishonesty or unethical conduct, I will not take it lightly. I will definitely be extremely, extremely upset.
Yes. Thank you for that. Can I then ask you to recollect that date on the affidavit of Ms. Ngoye?
That's the 3rd of April, 2018,
Indeed.
Chairperson.
Indeed. We now know that that affidavit gave rise to the findings made about the ethical conduct of Judge Makhubele, amongst others, by Judge Tuchten, which shocked you. In the context of the date of the affidavit which gave rise to these findings, can I ask you this? Do you know Mr. Fani Dingizoyo of Prasa?
Not at all. I've met him, Chairperson, the Friday, when the applications were set down for hearing in the unopposed court, my attention was directed. I think one of the liquidators informed me that that is Mr. Dingushwayo for specific reasons.
Yes. Should the tribunal proceed on the premise that you met him for the first time in court on the 9th of December 2017?
Chairperson, just allow me. There's a firm of attorneys in Pretoria, formerly known as Van der Merwe, Ferreira and Van Wyk Incorporated. They changed their name to VFV Incorporated. I know for a fact that there was also a certain Mr. Dingushwayo associated with the firm. Whether it was the same person, I haven't met him whilst he was at the firm, and I never received any briefs from him.
Yes. Well, he came to testify with a view to assist the tribunal in its investigative mission. And he mentioned your name, and he had a number of things to say about you. I'll get to those things in due course. The question for now is, have you had occasion to be apprised of what he said about you in his testimony?
Not at all, Chairperson.
We now know that Ms. Ngoye was the deponent to the affidavit which ultimately served before Judge Tuchten. When did the name Mathangoye come to your attention for the first time?
Chairperson, I can't recall the exact date, but throughout the communications I had with Judge Makhubele, the name was mentioned in that Mrs. Mathangoye was part of PRASA's legal department. More than that, Chairperson, I don't know. I don't know Mrs. Ngoye. I've never met her. I've never dealt with her.
Have you met her by any chance, any time in the course of your mandate on the CIA matters?
I was informed, Chairperson, on the same day that Mr. Fani Dingushwayo was at court when the 4 unopposed applications were enrolled, that one of the people present at the time on the 2nd floor included Mr. Mathangoye. May I just add, there was a presence of a number of people that specific day. It wasn't just 1, 2, or 3 people surrounding their counsel or me.
Yes.
But have you had occasion to speak to her?
No.
Not, okay. Your involvement in this Yaya matter was not concealed by Judge Makhubele to both Mr. Dingushwayo and Ms. Mathangoye. And you may not know this, but in the course of a memorandum she wrote to the chief executive officer, acting at the time, of PRASA, on the 28th of November 2017. She disclosed the approach the liquidators of CIDB made to her through you. And if you want to look at that, you can go to volume 8, I believe it's before you, at page 249.
I accept that, Chairperson.
Yes. I suggest to you, do you want to go to page 249 first?
I've got it in front of me, Chairperson.
And you'll see paragraph 5. Your name is mentioned there. Do you see that?
I see that, Chairperson.
And you can accept it as evidence before the tribunal that this report was directed to the CEO for the attention of, amongst others, Ms. Ngoye and Mr. Dingizwayo, and that they have looked at and they have received it, and they confirmed that they read it, so they would have been aware of your involvement in the Siyaya matter.
I accept that, Chairperson.
At best, or worst, depending on the perspective, by the 28th of November 2017.
I
see
saw
that?
that, Chairperson.
Now, the key question to you is, in the light of their knowledge of your involvement to you, in the light of the serious allegations they have made in the affidavit before Judge Dugden, has anyone, or has any of them, or has both of them, or someone on their behalf approached you to try and find out what your version of events is before the application was made to Judge Dugden?
No, Chairperson.
It's an unfair question to you, but I feel compelled to put to you. Because Mr. Dingizwayo made some serious assertion about you, and I'd like to test them with you. Can you think of any reason why they would not have approached you to establish your version in the light of the allegations they've made to Judge Dugden and the complaints which are now before this tribunal?
The obvious answer, Chairperson, is that PRASA was at all relevant times represented by attorneys and senior counsel, may I add. If either of them would have attempted to make contact with me or to solicit any response, knowing myself, Chairperson, I would have declined it.
Mr. Portes, I'd like to take you to the terms of reference which define the mandate of this tribunal. I wonder whether you have had an occasion to see them.
Unfortunately not, Chairperson.
If not, can I ask you to go to volume 3?
I do have volume 3, Chairperson.
And for the present purposes, I ask you to go to paragraph 5.1. You can read it. That's not what I'm interested in, but it will give you context to paragraph 5.2 on page 0133 of volume 3. 1033.
I have it in front of me, Chairperson.
You can read quietly paragraph 5.1 because it's a gateway to paragraph 5.2. Once you're done reading it, let me know so that I can take it to paragraph 5.2.
I've read it, Chairperson.
Let's read together paragraph 5.2. Whether the respondents, that is Judge Makhubele's conduct as a chairperson of PRASA, was incompatible with the office of a judge in that all of the cases that PRASA was involved in, she paid special attention only to those of Siyaya. We have evidence of Mr. Dingizwayo. I'm not going to bother you with that. That she marginalized the PRASA's legal unit and terminated or caused to be terminated the mandate of PRASA's attorneys and personally appointed another firm of attorneys in their stead to represent PRASA. Can I stop there and ask for your assistance so that the tribunal will at least have your version to the extent that you're able to assist? When you dealt with the CIA matter, are you able to confirm who represented PRASA in the course of those matters? From the date the summons were formulated, notices of intention were given, progressing to the arbitration, and ultimately to the orders made by Holland Mutter on the 9th of December.
March.
9th of March. 9th of December 2017. 2018, March, I'm sorry. March 2018.
That's correct, Chairperson.
That's where your involvement began and ended.
No, Chairperson.
All right.
My evidence in chief and my evidence in my response to the complaint is that I became involved in the CIA matters during May 2017.
Yes.
I was not privy to the preparation or the drafting of the particulars of claim or anything of that nature. When I received the instructions, what I read from the papers and the documents before me, it was Mr. Madimpi Makhubele, and may I add, that's also the first time I've met him, is by virtue of these matters.
Yes. I mean, my understanding of the evidence now, and you may correct me if I'm wrong, is that Mr. Makhubele has always and throughout been the attorney of record for PRASA.
I accept that, Chairperson.
And we now have evidence that what in fact happened is that he filed a notice of withdrawal on the 8th of, I think it was, of March 2018.
That's correct, and that was also according to my evidence in chief.
And you saw that notice of withdrawal.
I did, Chairperson.
I understand that he'll come tomorrow to explain how it came about that he filed a notice of withdrawal. But it's a matter that I'll take up with him tomorrow. You don't have to worry about it. As long as we are at one that throughout he acted as the attorney. Now, what I want to do is to take further what the terms of reference ask the tribunal to do. I have read up to the middle of the 5th sentence from the top of paragraph 5.2, ending with PRASA, semicolon. Do you see that?
You've read up until the 3rd line, only to those of CIA, and you stop there, Chairperson.
All right. That she marginalized the PRASA legal unit. Can I stop there and ask for your assistance? Do you have any evidence that you'd like to place before the tribunal about your knowledge of the legal unit of PRASA in relation to this matter?
Zero, Chairperson.
Thank you.
I don't know anything of PRASA's internal operations, how they're composed of. I never dealt with PRASA. I never acted against PRASA. I never acted for PRASA. So I'm the wrong guy to assist, Chairperson.
Yes. What I wish to take up with you on that score is that letter which you said is Annexure D of your statement in response to the complaint. And I'm afraid I worked with a different version in volume 8, if you don't mind.
It's on volume 8, Chairperson, more specifically.
Yeah, it's in volume 8, but it's also Annexure D of your statement.
Correct, Chairperson.
It's page 272.
Yes.
I suggest, for the purposes of the record so that when we then begin to reflect on the record, we refer to the same document so that there are no complications of cross-referencing. If you don't mind, can I deal with that document as 272, volume 8?
I'm comfortable with that, Chairperson.
Thank you. Now, you will see that that letter, you have been taken through it. I'm not going to take you through its terms again, except to confirm that it was dated 15 December 2017. And you'll find the date at page 274.
I see that,
Yeah.
Chairperson.
Mr. Dingiswayo testified about this document, and best I recall of his testimony was that he saw this document for the first time at court on the 9th of March 2018, and that you had gone to your chambers to fetch this document to prove to him that there was a resolution adopted by the PRASA board not to oppose the, to settle the matters. I'd like you to reflect on this document and tell the tribunal what your version is in the light of Mr. Dingiswayo's version.
Thank you, Chairperson. It was straightforward, Mr. Chairperson. When the attorneys who received instructions from PRASA, that's Bowman Gilfillan, and counsel, my colleague, arrived at court, they were unaware of these documents, the letter by Mr. Matopo, and may I add, Chairperson, the tenders which were made in accordance with the provisions of Rule 34, the tenders dated the 21st of December 2017. And I don't want to exaggerate, Mr. Chairperson, but they looked at me like there's something wrong. I mean, what are you talking about? Our chambers at the time was literally the block next to the High Court, and I said to them, whilst we have the opportunity, we're standing down, allow me to go to my chambers and to find these documents because I have it in my brief. So if that is Mr. Dingiswayo's recollection, he is 100% correct. I went back to court. I don't know if I made copies or not. I presented it to my opponent and his attorney. And I said to them, guys, this is what it is. This is how I understand it. This is my understanding of it. What on earth are you busy opposing? There's nothing to oppose. The matter became settled.
Okay, can I ask you this? And I'm sorry to belabor the point, because at some point the tribunal will have to make findings of fact. Who was your opponent at the time who represented PRASA?
Chairperson, I can't recall. It was junior counsel, male, very eloquent, very collegial. Yeah, upset, but nothing extraordinary. But I can't recall the surname. It wasn't senior counsel.
And the documents that you had in your possession at the time, including page 272 of volume 8, you made them available to PRASA's counsel at the time, including the attorneys.
Of course, Chairperson, because it was their documents. They should have known about these documents because it was authored by PRASA.
And I suppose that there was nothing to hide in that regard. I mean, you know, you were trying to ethically behave as open as you could.
Chairperson, a little bit further than that, I was attempting to do the right thing because I knew this is not private entities dealing with each other. We're dealing with public funds. And the more, there should be total transparency, honesty, and counsel should do the right thing. That's exactly why I literally disclosed everything, each and every conversation I had with Judge Makhubele, anything to avoid a situation where a finger is pointed and at me or at my attorneys or whoever, indicating that, listen, you did something wrong. I wanted to avoid that.
Thank you very much for that. Now, I'm sorry, I'm going to take you back to volume 3, the terms of reference. We're busy with them.
I have it in front of me, Chairperson.
We're now proceeding.
Line 4, Chairperson.
5.2 on page 1033. Are you there?
Yes, we were at line 4, Chairperson. Terminated or caused to be terminated. Then you stop there.
Yes. Do you have any information about whether Judge Makhubele terminated or caused to be terminated the appointment of Mr. Makhashwa?
Not at all, Chairperson.
And then next comes that she negotiated with Siyaya's attorneys and entered into a confidential settlement. Can I stop there? Are you aware of any negotiations that Judge Makhubele allegedly entered into with the Siyaya attorneys?
No, Chairperson. According to me, everything was above board. Correspondence were exchanged, which confirmed payment of the full capital which was claimed plus interest. According to me, there was nothing confidential. Everything was open and part of the, I don't want to say public domain because that's wrong, but within the confines of the litigating parties.
You represented the attorneys of Siyaya and Siyaya DB in liquidation and Siyaya Rail in the course of this.
CIA Holdings. That's the entity, Chairperson, to which I've referred to earlier in my, it's Rail Solutions, quite correct, Rail Solutions.
Indeed, indeed.
Sorry, Chairperson, correct.
Long time ago, memory being what it is fallible, understand that. But the point is, you are the best person to tell this tribunal about these types of complaint, including the allegation that she entered into negotiations with those attorneys who instructed you. And I can tell you now that Mr. Dingizwayo suggested to the tribunal that somewhere, somehow, there were concealed negotiations which were the product of the settlement letter at page 272 of volume 8. I'd like you to assist the tribunal in that regard. Were there, to your knowledge, any negotiations between Judge Makhubele and your attorneys?
Chairperson, all the negotiations which were attended to, as far as I'm concerned, I was part and party to it, and not Mr. Tsepu Matopu or Mr. Krause. I think, and that's just my assumption, you asked me, when Mr. Dingiswayo referred to that it was done secretly or that it was done confidentially, I think he referred to the fact that PRASA's legal department were totally unaware of it. But insofar as my involvement was concerned, there was nothing confidential, there was nothing done in secrecy. To the contrary, Chairperson, it was all disclosed and it was attended to in a transparent manner.
And I suggest to you that it was transparent because we have documentation here which we have discussed with a number of witnesses, which set out the footprint of what was done up to the point when these matters enjoyed the attention of the courts.
I accept that, Chairperson.
Can I then ask you to go to the terms of reference?
We're at the 6th line.
At 0133, volume 3, page, paragraph 5.2. Mr. Dingizwayo took issue and suggested that the settlement was secret because it had a confidential clause in it. I suppose that you remember the offers also referred to confidentiality. You see that?
I recall that, Chairperson. That is all contained in paragraph 2.1 of the letter dated the 15th of December 2017.
Indeed. What should the tribunal, on your version, read from the fact that the office and the letter of 15 December 2017 referenced confidentiality relating to the terms and conditions of settlement?
Chairperson, insofar as I was concerned, it was superfluous to add any suggestion of confidentiality, because once it's within the domain of the arbitration before Judge Brandt, or once it is within the public domain, when applications were initiated in accordance with the provisions of Section 31 of the Arbitration Act, there's no more confidentiality. It's open for anybody's knowledge and for everybody to see. And may I add, it would have been from where I was standing, nobody would have persuaded me to deal with these settlements or awards or applications in a clandestine or secret manner. That's not how I operate.
Can we go back to the terms of reference?
We're at line 7.
Yes. And they say it's a confidential settlement agreement that is manifestly and materially prejudicial to the interests of PRASA, relying on non-existent major concessions on its liability to Siaya, allegedly made by PRASA employees at the insolvency inquiry. Do you see that?
I see that, Chairperson.
I'm afraid here I'm going to take a bit of time with you because I want to track and trace your version relating to this part of the terms of reference, if you don't mind.
I don't mind at all, Chairperson.
And my starting point is to refer you to the email that was part and parcel of the bundle that you gave to Judge Makhubele in November 2017. And you will see that email in volume 19 from page 76. You have given your testimony around the reason for writing that email, but for now, I'd like to confirm that initially this is the email you sent to Mr. Mukhashwa and not to Judge Makhubele.
This email was dispatched to Mr. Mukhashwa. Chairperson, you will also see that it was CC'd and blind copied to a number of people, including Mr. Matopu, including a certain Mr. or Mrs. Seti Baza, and Advocate Kennedy Tsatswane. Is that the right pronunciation?
Tsatsawane.
Tsatswane, I'll get it. Mr. Van Wyk, Mr. Skuman, Mr. Johan Krause, and Mr. Hannes Miller at Tshwane Trust, and also Isaac at Tshwane Trust. Reason being, once again, I would include everybody at the time when I prepared this email, and if my memory serves me correct, Chairperson, the 6th of September 2017 was a Sunday when this was prepared. I wouldn't have hidden any information from any person who had an interest herein.
Thank you. I'll skip paragraph unnumbered, the first unnumbered paragraph, because it talks about the discussions you had with Tsatsawan SC about the prospects of postponement. My understanding of what you're trying to convey there is that there was some sort of a discussion between you and Mr. Tsatsawane around the question of postponement of the arbitration at that point in time.
Quite correct.
Not concerned about that.
And
then,
I add that we were on the same page.
yes. What I wish to do is to reflect on the third unnumbered paragraph from the top, and let me read it out to make sure that we're together. You say, I will ask the Commissioner Krige to expedite his report so that it can be discovered in accordance with the provisions of Rule 35. I believe that the record is in the process of being finalized. Once we are in possession of the record, it will be discovered in accordance with the provisions of Rule 35. And you conclude, the record speaks for itself. Re ipsa loquitur. My Latin is so poor, but I hope that the pronunciation is not far from its true import. The simple point I'd like to establish with you at this stage is that you referenced Mr. Krige, who chaired the 417-418 inquiry, correct?
That's correct, Chairperson.
And you said that that record will speak for itself. And why did you say so to the recipients of this email?
Chairperson, for a very specific reason. On my understanding of the evidence that was tendered by the employees and representatives of PRASA at the inquiry before Mr. Neil Krige, there was no doubt that some, not everything, which was claimed by the plaintiffs were due and payable. So much was conceded. And allow me, if one reads the record that was prepared, so much is evident. And I accept, for purposes of this hearing, that some information was still outstanding, and those witnesses, Chairperson, indicated, and they were prepared to liaise with certain individuals so as to finalize that. If I say I will liaise with Mr. Neil Krige, I don't have any contact, or I've never liaised with him. I mean through the instructing attorney, because what he said, what he indicated, not what he said, is that he will prepare and finalize his report as soon as practically possible.
I will invite you to comment on what Mr. Dingizwayo said about this inquiry later on, but at the moment I'm exploring the terms of reference. And to telescope what I would like you to comment on about his version. He says this was one of the strangest 417 inquiry he has come across, and that at best it was just pushing paper. But I'd like to be faithful to the words he used so far as I have noted them, and I'll paraphrase them to you. But for now, if anyone were to suggest to you that this inquiry was no more than the pushing of paper, what would be your comment?
Chairperson, the opposite. No paper was pushed. We prepared proper bundles. Proper consultations were held. And insofar as I could recall, Mr. Dinguswayo wasn't present at that inquiry. The only people who were present were the people referred to in Mr. Krige's report in paragraph 3. So how Mr. Dinguswayo can make an allegation like that under oath is disturbing. Because from my perspective, Chairperson, I put in a lot of effort to make sure that the correct information is placed before the insolvency inquiry, before Mr. Krige. And as you could see from the record, There were some instances, Chairperson, where witnesses were about to be excused. And when I alerted them and said, hold on, there's something else that I need to canvass and to take up with you. No, I don't think that is a fair or an accurate description of what transpired at that inquiry.
You know, Mr. Botus, you are more experienced than me on insolvency inquiries. But my little understanding of those inquiries is that they are initiated at times upon application by a liquidating creditor. And that application is a substantive application made under oath to the master. Are you aware of that? I see you shake your heads up and down.
Yeah, that's true. That's true. There must be an application, Chairperson, to the master to initiate or to establish such an inquiry so that a chairperson can be appointed and that the procedure can be attended to orderly as provided for in sections 417 and 418 of the Companies Act. Quite correct, Chairperson.
Yes. So that's one of the route to appointing or establishing a 417 inquiry.
Quite correct, Chairperson.
The other is, of course, the court itself may appoint a liquidator, sorry, a commissioner.
Chairperson, no, that's not how I understand it. There is a judgment by His Lordship, Mr. Justice Bertelsmann, as he then was, which said that the court shouldn't enter into that arena. That is an administrative function that should be attended to by the master, and if anybody is aggrieved or doesn't agree with it, then that's open to be tested in a review application, either in terms of PAJA or in terms of the common law.
Yes. Thank you for that clarity. You represented the liquidators in this case.
In this insolvency inquiry?
Yes.
Yes, I did.
Can you clarify for us how Mr. Krieger was appointed?
No, I wasn't involved in it. When I received instructions, that was already attended to, that was already done. When I became involved, the only thing that was still outstanding, Chairperson, is for dates to be secured when everybody is available for the inquiry to kick off. But I wasn't involved in the manner in which it was appointed. I haven't seen the application to the master. I was not part and party to that.
Yes. Mr. Dingiswaya took issue with the fact that although the company in liquidation was CIRDB, the inquiry dealt with matters beyond CIRDB and also dealt with claims PRASA launched against CIR Rail. My understanding is that the scope of the inquiry under 417 and 418 is broad, and it relates to the affairs of the company and any other matter the commissioner may consider relevant to deal with. What is your understanding about the scope of an inquiry in the light of what Mr. Dingiswaya has suggested to the tribunal?
As you've alluded to, Chairperson, that's also how I understand the scope and the ambit of insolvency inquiry.
To your knowledge, was anything untoward in Mr. Krieger dealing with the claims of CIR Rail against PRASA?
As things are, Chairperson, I asked the questions and I took the initiative to ask the questions pertaining to CIR Rail as well. Mr. Dingiswaya was present, also Advocate Tsatswane SC. Nobody objected thereto, and the commissioner allowed it. So that's the manner in which I attended to establish what exactly was due and payable by PRASA.
You referred to Mr. Dingiswaya. Suppose you wanted to say Mr. Makhashwa.
Mr. Makhashwa, apologize. I'm thinking about something else. Mr. Madibu Makhashwa. Apologies for that.
Yes. Sorry to do this to you, but can you go to page 76?
I am at 76.
The next paragraph, which is the penultimate paragraph from the bottom, in your email you say, you were present at the insolvency inquiry and you personally witnessed the testimony of your client's employees and former employees under oath. You and Kennedy, I take it that is Mr. Tsatsawane, witnessed the material and fundamental concessions and admissions that were made by your client's employees and former employees. Do you see that?
I see that, Chairperson.
This is the first document which I have come across as between your communication and Judge Makhubele, which for the first time mentions material and fundamental concessions. Do you see that?
I see that, Chairperson.
It seems to me that that is what you drew from your knowledge of the proceedings at the 417 inquiry.
Quite correct, Chairperson.
And Judge Makhubele was not involved at this stage when you drew this conclusion.
No?
And you communicated this conclusion, amongst others, to Mr. Mokhasho and to our colleague, Tsatsawane SC. Do you see that?
I see that, Chairperson.
Was there any response from Mr. Mokhasho or anyone acting on behalf of PRASA to contest this observation you made around material and fundamental concessions and admissions at the inquiry?
Not that I'm aware of, Chairperson.
You have exchanged several, well, let me not say you, your attorneys, Matopo attorneys, and the attorneys of PRASA through Mr. Mokhasho, exchanged several letters that led to the formal Rule 41 offers.
Rule 31.
Rule 31 offers, my apologies. Really apologize. Your observation around material and fundamental concessions and admissions, were they ever disputed by anyone on behalf of PRASA in the course of the exchanges of correspondence between them?
Not that I'm aware of, Chairperson.
Then, in the last paragraph on page 76, you talk about the concession which was made by Mr. Baltak. Do you see that?
Mr. Soren Baltak.
Yes. I've read the transcript of the questions you posed to him and the answers he gave. And if necessary, we may take you there. But at the end of noting the concession he made with reference to that claim under the case number you reference to the order of 21 odd million rand, you draw a conclusion at the end of that paragraph. You say, my instructions are that Mr. Soren Baltak verified the amount due and payable to by PRASA to Siaya being 19.7 million rand. This amount is therefore not in dispute, and your client should pay it immediately in full and final settlement of the claim in respect of case number dash. And you pose a question thereafter, which is quite key. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
I see that, Chairperson.
Was there any response to you to that question you posed in this email?
Not that I'm aware of, Chairperson.
What I find interesting about the events which evolved after this is that Judge Makhubele was not even involved at this point in time when you exchanged this email with, amongst others, process attorneys.
I accept that, Chairperson.
And then in paragraph 70, sorry, at page 77, the second unnumbered paragraph. Sorry, before I go there, can I ask you this? Do you know that when Judge Makhubele got involved in this case, after you sent the report of Mr. Krige and this email to him. He called for those witnesses who testified at the inquiry to make reports about what they said at the inquiry.
He recalled Mr. Krige.
No, rephrase. Do you know that Judge Makhubele called for the witnesses who testified at the inquiry to give her reports of what they said at the inquiry?
No, Chairperson, I'm unaware of that.
Well,
No, sorry, when you referred to him, I assumed you referred to Mr. Neil Krige.
amongst others, he called for Mr. Baltak to give her a report of his version of events at the 417 inquiry. Do you know that?
Unaware of that,
Well,
Chairperson?
It is important, and I interrupt myself. I'll come back to your email, but I'd like to take you to what Mr. Baltak has said, because it seems to me that what you have said in this email is what Mr. Baltak himself has said in the report to Judge Makhubele. The report is in volume 8.
I have it in front of me, Chairperson.
If you go to page 258,
I'm there, Chairperson.
you are welcome to read it if you have not seen it before. I take it that this is the first time you see this document.
I haven't seen it before, Chairperson. I have read it.
Yes.
Why isn't payment coming?
Well, in fact, I made a mistake. The report begins at page 257.
Yeah, I just read on 258, the last paragraph, and it's dated the 30th of November 2017. But you're correct, Chairperson.
Yes.
It starts at 257.
For now, I'd like you to look at the last two unnumbered paragraphs, which are
Okay.
followed by subparagraphs.
I'm there, Chairperson.
In his report to the chairperson, he says the following. In essence, I have been asked by the commissioner to answer to the following three questions regarding resignaling projects. One, did CIA fulfill their contractual obligations? Do you see that?
Yes, I do, Chairperson.
His answer to that question follows under the subheading, my answers to the three questions.
Yes, in my opinion.
Yes. And I suppose this is consistent with what he told you when you questioned him at the inquiry.
That's how I perceive the Chairperson.
Next, number two, has CIA been remunerated for the work done? The answer, I was aware there were instances when CIA have not been paid for the work done. Do you see that?
I see that, Chairperson.
Is that what he said to the inquiry?
He said no. Although he agreed and conceded, my understanding, that the money should have been paid, it was due and payable, monies were not forthcoming.
Three, if there is any payment outstanding towards CIA, SLR produce a list of CIA unpaid invoices. Do you see that?
I see that, Chairperson.
And then the answer is, I need to look in the file and consult with my colleague, Johan Edwards, Chief Engineer, Signal, in order to come up with a reliable response. Do you see that?
I see that, and that was also in accordance with his testimony in the inquiry.
Indeed. And you say that he ended his testimony on the basis that he will go back and look at his information and thereafter consult with senior officials of CIA to come up with a figure.
That is correct, Chairperson. Hence, my sentence, my instructions are, because subsequent to the insolvency inquiry, such a meeting was held. I wasn't present.
Yes.
That's why I use the words, my instructions are.
Indeed. And I'll get back to you the question of what information was placed before Mr. Krige after Mr. Baltak and others were excused from the inquiry. But for now, I'd like to ask you to look at the last paragraph of Mr. Baltak's report to the chairperson at page 258.
I've looked at the chairperson.
It says, after the testimony, PRASA Legal Department has instructed me not to enter in any discussion with Mackenza Mabunda. Who's Mackenza Mabunda?
He was the director. I can't recall, chairperson, if he was the sole director, but he was definitely a director of CIA DB Engineering as well as CIA Rail Solutions. And I don't know if I established or whether I've investigated whether he was also a shareholder or not, but he was definitely a director, chairperson.
Yes. Oh, with the commissioner, my involvement by now in this process was finished with this instruction. We took up this part of his report, Mr. Baltak's report, with both Ms. Ngoye and Mr. Dingizwayo. And they indicated to the tribunal that they did not give such instruction. You may not know about it and you may not be able to assist the tribunal on that score. But what I wanted to comment on is what he did when he was excused from the 417 inquiry by Mr. Krieger. What did he undertake to do?
He should have liaised with Mr. Edwards so that they can verify the certain outstanding aspects which were alluded to and highlighted during his testimony in the inquiry before Mr. Krieger.
Yes. I'm sorry, I'm going to take you back to your email.
I have it in front of me, chairperson.
Yes, we are now at page 77. The second unnumbered paragraph. Your clients, Mr. Tony Vermeulen, conceded that PRASA is liable and responsible to pay an amount of at least 2 million and 3 million to Siaya in respect of the claim which forms the subject matter of Siaya's claim under case number so-and-so. Do you see that?
I see that, chairperson.
You will recall that Mr. Vermeulen initially mentioned that, quote, an amount of approximately 5 million, close quote, is due and payable, but immediately corrected himself. His explanation in this regard was that it is a matter of interpretation. Do you recall his testimony in this regard? Do you see that?
I do see that, chairperson.
A senior practitioner like you calling for this inquiry or posing a question like this would expect an answer from a fellow colleague, correct?
Mr. Vermeulen, chairperson, was, to my understanding, a little bit of a moving target. He didn't want to confine himself to a specific number. Reason being, and that's the impression that I got, is that he didn't have all the documents in his possession. And I don't want to be unfair to Mr. Vermeulen, but to a certain extent, he was a little bit evasive in his testimony.
Yes. And then you conclude as follows on Mr. Vermeulen's evidence.
It's Vermeulen, my lord, chairperson.
Commissioner Krieger excused Mr. Vermeulen to afford him and Mr. Mabunda an opportunity to meet and to verify the correct amount that is due and payable by PRASA to Siaya. Do you see that?
I see that, chairperson.
Mr. Vermeulen was keen to resolve this dispute and to do his best to liaise with Mr. Mabunda to settle this claim. My instructions are that this meeting will take place on Friday, 8 February 2017. We are eagerly awaiting the outcome of these discussions. Does your client persist in pursuing the arbitration against this backdrop? Do you see that?
I see that, chairperson.
To your knowledge, did Mr. Mabunda and Mr. Vermeulen meet?
No, I don't know. May I just on this point,
Yes.
just add, whilst the inquiry was in the process, the impression that I got is that these people, if I say these people, Mr. Mabunda and representatives of PRASA, knew each other very well as they worked together with each other in the execution of these various projects. And they were on good foot with each other, so to speak. So during the course of the inquiry and even in breaks, Chairperson, they had cordial discussions and they made jokes with each other. The impression that I got is that the relationships were not strained and there wasn't any tension between these people.
You see. Chair, as I recall, the testimony was that Mr. Vermeulen had left by the time the chairperson called for the reports, and therefore none could be obtained from him. That's my recollection.
Chairperson, if I may, Mr. Vermeulen mentioned, and that's why a date was set, as it appears in my email, that his days were numbered, and that was, if my recollection is correct, that he was about to retire.
Did you get any answer to your question around whether PRASA is persisting with the arbitration in the light of Mr. Vermeulen's evidence?
No, Chairperson, all the matters subsequently became settled.
I understand, but they were settled as a result of the intervention of the chairperson.
I accept that
Yes.
unconditionally.
I want to understand from those who you addressed this email to, whether they came back to you on this.
No response, Chairperson.
No response.
No, there was no communication or response in response to my email. That's my testimony.
Yes. And then the second last paragraph, you say, your client, Mr. Maishe Bupape, conceded under oath that PRASA is liable and responsible to pay an amount of 8 odd million in respect of CIA claim, which forms the subject matter of the claim instituted under, and you give the case number. Do you see that?
I see that, Chairperson.
And you say he further confirmed that the works were executed to PRASA satisfaction. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
Quite correct, Chairperson.
And then you go on and say the following further about Mr. Bupape. Mr. Makhubele Bupape further admitted and confirmed under oath that PRASA is liable and responsible to pay at least 14 million rand to CIA in respect of its claim, which forms the subject matter of case number, and it's a different case number. Do you see that?
I see that, Chairperson.
You were present when this was conversed with Mr. Bupape. Mr. Bupape was the author of the memorandum dated 2 June 2015, Annexure POC 18. Do you see that?
I see that, Chairperson.
Was this an annexure to the particulars of claim?
It was indeed, Chairperson, under that case number, which was not part and parcel of the matters which went under to arbitration.
And you asked the same question about whether PRASA will still pursue the arbitration in the light of Mr. Bupape's evidence under oath, making serious concessions. Do you see that?
Quite correct, Chairperson.
Again, I want your answers to be on record. Any answer to it?
Not as insofar as I'm aware of, Chairperson.
Then you deal with Mr. Lucky Montana, and you mention the case number and the concessions he made. Do you see that?
I see that, Chairperson.
And then you also deal with Mr. Montana again in the next paragraph. Let me be clear. In the first reference to Mr. Montana, it's under case number 74281-2015. Do you see that?
74, yeah, I see that, Chairperson. 74281, yes, correct.
And the concession he made in that regard is 17 odd million rand. Do you see that?
I see that, 17628.
And the second reference to Mr. Montana, it's about case number 47598. Do you see that?
Of 2015, I see that, Chairperson.
And the liability conceded was 15 odd million rand. Do you see that?
I see that, Chairperson.
Now, can I stop here? You confirm that the evidence of these witnesses and the concessions they made were under oath. Do you see that? You confirm that?
Definitely,
Yes.
Chairperson. I made sure that the oath was administered. I don't want a situation that afterwards somebody say there's a technical issue if one goes on to summons or application.
These are process employees, some of whom had personal knowledge about the project, and they have lived with those projects up to the point when this inquiry was held. What would be the point of going to trial in order to debate once again the question of the liability of PRASA in the light of these concessions?
You take the words out of my mouth, Chairperson. You're preaching to the converted. That's exactly what my view was. Why waste millions or hundreds of thousands of rands of public funds to go on trial when these people made the concessions as provided for and contained in the record before Mr. Neil Krieger? And on a proper analysis, you took me through this, Chairperson. How many times did I ask the question, does your client persist in pursuing the arbitration under these circumstances? I was extremely frustrated at the time because there was pushback, and according to me, right or wrong, is that certain concessions were made, money must be forthcoming.
Make sure that I've...
Then I said with great respect on page 78, PRASA doesn't have a leg to stand on, nor does it have a valid defence in law. I haven't heard that defence yet.
The version of Mr. Dingiswayo, which I'd like you to reflect on in the light of your email, is to the following effect. And maybe before I put that version to you, let me establish the facts. You say that you were instructed to handle these 4 matters on behalf of the liquidators and the Sierra Rail, correct?
That's correct, Chairperson?
Were you involved in the formulation of the claims?
No, Chairperson.
Do you know
Not at
who formulated the claims?
I believe counsel's name. No, I know. He assisted me in the preparation, Advocate Louis Hollander, if my memory serves me correct. He was the draftsman of the particulars of claim.
Yes. Mr. Dingiswaya says that the claims were so badly drafted that they did not make sense at all. And I see that you smile, I mean, even before I finish my question.
Chairperson, I don't want to be disrespectful towards you, not at all. I went through it comprehensively. I know Advocate Louis Hollander extremely well, to such an extent that I extended an invitation to him that whenever he thinks that the time has arrived for him to apply for elevation, for senior status, it will be a privilege for me to give him a letter of recommendation or to support him.
Yes. Mr. Dingiswaya also indicated that PRASA took exception. I'm not too sure whether it was an exception to all of the claim or to some of them. Are you aware of those exceptions?
There were no exceptions, Chairperson. May I add, the original pleas which were filed, and once again, I don't want to do PRASA any injustice, 3 pages, maybe 4 pages, all of which constituted bare denials. And that was a problem, that was a concern that I had. But regard being had to the fact that it was decided to go on to arbitration, the defences or the notices, the statements of defences were much better drafted at the time, as was the original pleas.
Mr. Dingiswaya suggested that you were the ones who were delaying the prosecution of the claims. I think the phrase he melodramatically used was that you were stuck in your own mud.
Stuck in my?
Mud.
Mud.
Yes. It's just you had problems in progressing these claims as the plaintiffs.
Chairperson, not at all. We were frustrated because, one, there were no defense. Secondly, after the insolvency inquiry, I mean, I was astonished. I mean, I asked myself, and when we had our private discussions between attorney and counsel, I mean, what on earth? What are these people doing? They're just kicking the can down the road and playing for time, and under circumstances where the public's funds should be used in a different manner and fashion.
Can I ask you to look at the last part of the terms of reference at page 1033, volume 3?
I have it, Chairperson.
And it reads as follows, and that's the last part. And frustrated process attempts to resist the enforcement of the settlement, and thereby rendering herself guilty of gross misconduct as envisaged in section 177 of the Constitution. Can I ask you this? When did your client begin with legal steps to enforce the settlement that was reached pursuant to that letter of, I think it's 15 or 17 December 2017?
The letter of PRASA, Chairperson, was dated the 15th of December 2017. Then the arbitration awards should still have been made, because you recall, Chairperson, that formal tenders, in accordance with the provisions of Rule 34(1) of the Uniform Rules of the High Court, were submitted, and that date, Chairperson, was 21 December of the same year. So all of which could only come to fruition by virtue of a court order, and because, notwithstanding the fact that the awards were made by the Honourable retired Mr. Justice Brandt on the 7th of February, no monies were forthcoming, and then the decision was taken, upon my advice, to initiate the 4 applications in accordance with the provisions of Section 31 of the Arbitration Act.
Yes. My understanding is that the first resistance, if any, from PRASA was to oppose the applications by your client to make the awards orders of court.
Maybe.
That's the first time a notice of intention to oppose was filed on the eve of the hearing of those 4 applications.
Correct, Chairperson. There were no other formal steps taken so as to oppose the 4 applications, and you're quite right. On the 8th of March, those 4 notices of intention to oppose were disseminated electronically, and I believe subsequently filed on the court file. The judges attending to the matters were informed of it accordingly.
Yes. Normally, when you oppose something as substantive as the applications you had, there has to be an explanation of the basis of your opposition. What I want to ask you is this: had PRASA at around the 8th or the 9th, before the applications were heard, filed any affidavit to explain what would be the basis of opposing the applications by your clients to get the awards confirmed as orders of court?
Chairperson, no, and that was one of the issues that I've discussed and canvassed with my opponent. Just allow me. I asked my opponent and the instructing attorney or attorneys who were with him, whilst we are engaging with each other, give me a piece of your mind. What is your client's defense? And he said to me, I don't have instructions in that regard.
All that Judge Holland Mutter acting and Judge Petersen also acting had, at best for PRASA at that point in time, were mere notices of opposition, of intention to oppose.
More than that, Chairperson, notices of intention to oppose. The letter that was filed on the court file, that is Mr. Matopo's letter, as well as the notices in terms of Rule 7 of the Uniform Rules of the High Court, in terms of which the legal representatives were requested to submit the decisions or the instructions, the resolutions adopted, which gave them the necessary standing so as to oppose.
That's a separate matter, but I'll get to it if you feel compelled that we should deal with it now. But I was going to deal with it.
I'm just referring
Yes,
to
yes.
it, Chairperson.
Yeah. I mean, the sum total of what I'm trying to establish from you is that there was no indication of what will be the basis to oppose the applications on the merits.
Correct, Chairperson?
And the difficulty I would like to put to you is this. In the light of the email that we have looked at, your email of 6 September 2017, what would you expect a party who opposes the arbitration award to be made an order of court to do on the merits of the application?
Play open cards and submit your defense, which is, in my view, or should, in my view, be a valid, sustainable, enforceable defense. Not, as I've said, in paragraph on page 79 of my email, where I said in the second paragraph from the top, let's not play cat and mouse with each other, Madimpi.
Can I get to the question that you raised earlier about the notice of intention to oppose? It's now common cause that it was filed by Bowman.
Bowman Gilfillan Incorporated, yes, Chairperson.
Shorthand for Bowman Gilfillan Inc.
I accept that.
Yes. You say that you could not believe that those attorneys who would be acting for PRASA to oppose, in the light of what you knew by that point in time, including the awards that were made orders of court, correct?
That's correct, Chairperson.
And you say you advised your client to issue a Rule 7 notice.
That's correct, Chairperson.
And as I recall, that is a rule that empowers a party to litigation to call the opposing attorney to file a power of attorney if you don't trust that they have the authority to act on behalf of their clients, correct?
100% correct, Chairperson.
Yes. And you can establish authority by filing a formal power of attorney, which is a document attorneys ordinarily give to their, the clients ordinarily give to their attorneys at the commencement of litigious matters, correct?
That's exactly what the case law provides for, Chairperson.
Or you can establish your authority through other ways, including affidavits or board resolutions
Quite correct, Chairperson.
by the opposing litigant, correct?
That's exactly what the case law alludes to.
Yes. And you wanted proof of the authority, correct?
That's correct, Chairperson.
And did Bowman, shorthand again, ever give you that proof of authority?
As per my evidence in chief, Chairperson, no. They were not in a position to do so.
Yes. And you then made contact with Judge Makhubele to try and establish the facts, correct?
Chairperson, my understanding was that this was already canvassed. If one have, yes, I made contact. Yes, quite correct, yes.
Really, the point of the inquiry is this, that it is not Judge Makhubele who initiated the contact. You are the one who initiated the contact with her.
Quite correct, yes, because there was now confusion of whether or not these people, not disrespectful, Bauman Gilfillan Incorporated, had a valid mandate from PRASA to oppose these applications. And I was really concerned, Chairperson, and if the answer would come, yes, these matters are opposed, I will be the first person to raise the issue and say, hold on, we can't continue with this.
Yes. And Judge Makhubele had nothing to hide. She told you the facts as she knew them by that point in time.
Mr. Chairperson, I accepted Judge Makhubele's word unconditionally.
Yes. And the evidence is here. If you doubt it, then we would invite your comment. The tribunal has heard that by the 1st of December 2017, the special board meeting of the interim board of control chaired by Judge Makhubele had taken a resolution to suspend the panel of lawyers who had been on the list of service providers for PRASA in a manner that concerned the Auditor General, and the Auditor General had found that that panel was irregular. Do you know anything about that?
I don't know anything about it, but on a proper reading of the complaint that Judge Makhubele laid against me, that is reflected in that complaint as you've just put it to me, Chairperson.
Yes. And she did confirm with you that Barman was not on the panel of attorneys, and that at that point in time, the Board of Control took the view that the panel of attorneys to be used was from SACA.
That is what is provided for and contained in the SMS, which Judge Makhubele disseminated to me.
I'd like to draw your attention to that part of the resolution. I'm not going to be long, because I'd like to confirm with you that what Judge Makhubele told you in that SMS is something that is truthful and reflected in the documents which the tribunal has before it.
That's contained in paragraph 33 of Judge Makhubele's complaint against me.
Oh, you saw that?
Yes, I've got it in front of me.
Thank you.
And I've alluded to it in my evidence in chief.
I don't want to go there. Yes. I'd like you to consider the report of Mr. Krige, because something was made about it, essentially by both Ms. Ngoye and Mr. Dingizwayo. You'll find it again in volume 6 of 1.
Volume 6, Chairperson.
Yeah. It's let's use volume 19.
19.
Because it is part and parcel of your...
I have volume 19 in front of me, Chairperson.
It is Annexure B. Do you see that?
Page
65.
65. Yes, Chairperson, I have it in front of me.
I would seek your guidance on this score. My understanding is that 417, 418 inquiries are confidential hearings,
That's correct, Chairperson.
and that the report, which is ultimately compiled by the commissioner, if the master himself or herself was not a commissioner, it is sent to the master.
Quite correct, and can only be used, or it can only be dealt with or communicated to people other than those involved in the inquiry with the master's consent, Chairperson.
Indeed. If you want access to that report, you'd have to apply to the master.
You do bring such an application to the master, that's correct, Chairperson?
Yes. And I think there's a provision in one of the subsections of 418 that a witness who testified before the commissioner would be entitled to have copy of his testimony or her testimony
That's my understanding as well, Chairperson.
made available to him or her upon application.
That's my understanding as well, Chairperson.
Would you read anything to the fact that this report, after it was compiled by Mr. Kruge, was not made available to PRASA?
Not at all, Chairperson. Insofar as I was concerned, it was disclosed or disseminated to PRASA's legal representatives. Whether or not, in fact, it was done, I can't testify to. I don't know.
It would have been open to the attorneys of PRASA or to PRASA itself through its attorneys to apply to the master to get this report.
I accept that, Chairperson. And that is also why I took the initiative to take Judge Makhubele in my confidence when I provided her with my documents, my bundle, which consisted of 17 pages.
And I take it that you got instructions from your attorneys before you released this information to Judge Makhubele?
Definitely so, Chairperson.
Now, in terms of the findings that the liquidator made, and I'd like to quickly take you through this so that there ought not to be any confusion or debate when we ultimately argue in your absence. Look at page 66.
I am at page 66, Chairperson.
In paragraphs 3.1 and 3.2, Mr. Kruger records persons who attended the inquiry. Do you see that?
I do, Chairperson.
Yes. And then in paragraph 4, he records those who were present. Do you see that?
I see that, Chairperson.
And your email summarizes who said what at those proceedings. I'm not going to...
Paraphrased, yes, Chairperson.
Indeed. And then paragraph 5, he summarizes the evidence, and he goes through each and every witness who testified there. And you will see, for instance, he begins with the evidence of Mr. Baltak at page 66, paragraph 5.1. Do you see that?
That's correct, Chairperson.
And then he goes on to analyze his evidence and then gets to various case numbers and memorandum. And he then gets to the evidence of I think it's Mr. Vermeulen. Well, he deals with Mr. Bupapa first at 5.2 on page 6.8.
That's correct,
Do you see that?
Chairperson.
And in your evidence, you summarize the concessions that he made. We're not going to go there. And then, if you go to page 71, paragraph 5.3, he deals with the evidence of Mr. Vermeulen. Do you see that?
That's correct, Chairperson.
And then he deals with the evidence of Mr. Kobue at paragraph 5.4. Do you see that?
I do, Chairperson.
And then at 5.5, he deals with the evidence of Mr. Montana.
That's indeed correct, Chairperson.
What I suggest to you, and we will argue this at the end of the day, that the fact that the report was not made available to PRASA or its attorneys is simply irrelevant in the light of the email that you addressed to them, summarizing their testimony. Would that be a fair argument to make to the inquiry at the end of the day?
It's difficult for me, Chairperson, to make a pronouncement on that score, I think the right answer is, once the tribunal have all the evidence, that's something that the tribunal should attend to and should consider. But everything that I know, and throughout my involvement in this matter, everything that's before this tribunal, this is the extent of what I can testify to personally.
No, Mr. Botis, I'm afraid I'm going to repeat the question and invite you to comment on it, because you're here to assist the tribunal and us. The point is that you have summarized what happened to the inquiry.
Yes.
I have taken you through your email, and I've taken you through parts of the reports where Mr. Krieger referenced the various portions of the evidence from witnesses and the concessions they made.
That is so, Chairperson.
I don't see any difference, at least of a material nature, between your email to Mr. Mahashwa and what Mr. Krieger has reported in his report.
Of course. Yes, I agree 100% with you, and that is where I obtained that is what made me so frustrated to a large extent, because it was feeling I was getting the impression that we're going nowhere fast.
The same document, the two documents recycle the same thing in different ways.
Yeah, I agree. Whether it's 2 plus 2 or 3 plus 1, the result is the same.
Yes. You have made some observations about your relationship with Judge Makhubele when she was at the bar.
I did.
And you indicated that at some point she was the chairperson of the then Pretoria Bar Council, correct?
That is indeed so, Chairperson.
Can you give us some days that we would work on your evidence? We will lead her evidence, but just indicate to us, to the best of our recollection, when she became the chair of the bar.
Sorry, Chairperson, I just lost you for a minute. Just rephrase.
When was Judge Makhubele the chairperson of the Pretoria Bar Council?
I can't recall exactly. I was on the Bar Council for more than 12 years. Exactly when, if my recollection is, that was just after Norman Davis, now Davis J, Davis SC, was the chairperson.
You can give some indication around which period?
2014, 2015, chairperson, if my memory is correct.
Judge Makhubele says that it was around 2015, 2016.
There we are.
Yes. Now, in your affidavit, in response to the complaint she lodged against you,
That was the response, yes.
at page 47 of volume 19,
I have it in front of me.
you make certain observations about your relationship with her.
Paragraph 9.
And I'd like you to seriously look at them in the light of what I put to you as the version of Mr. Dingizoya. I know that it is not the full version, but I can tell you now that both Ms. Dingizoya and Ms. Ngoye have made serious allegations about the integrity of Judge Makhubele. I have given you some excerpts of what they said, and I'd like you to reflect on what they said in the light of your knowledge of Judge Makhubele. And I begin in paragraph 9 on page 47. Are you there?
I'm there.
You say Judge Makhubele and I know each other since 1997, correct?
Yeah, that's factually incorrect. It subsequently transpired that Judge Makhubele only became a member of the Pretoria Society of Advocates in 1999. I wrongly labored under the misconception that Judge Makhubele is in seniority as membership of the Pretoria Society of Advocates, my senior.
So you would be comfortable if we strike out 7 for 9?
Totally comfortable. Thank you, Chairperson.
We served together on the Bar Council and her integrity, dignity, and ethical values and honesty were never in doubt.
That's correct. That was my perception of Judge Makhubele when I have known her, dealt with her, and liaised with her. We were never opponents in legal matters. We never worked together on legal matters. But the manner in which she attended to affairs of the Bar Council, Chairperson, some meetings of the Bar Council became heated and to a large extent personal. And whenever the spotlight was on Judge Makhubele, she held her composure. She dealt with the affairs insofar as I was concerned in the manner described too in this paragraph. And there was absolutely no, and if I say no, I emphasize no, reason for me to doubt Judge Makhubele's integrity, honesty, or gravitas at all.
You repeated the same sentiments today when you started your testimony.
Yes, and may I add, even after this transpired, whilst Judge Makhubele was still attending to matters in her court, I appeared when she was attending to urgent court in a matter on behalf of the applicant. I said to my instructing attorney, you know, this is what transpired. I hope that that things stay cordial and professional between us, exactly how it transpired. It was only later, much later, that Judge Makhubele, and that's the last appearance I had in front of her, where she suggested and she said to me, Mr. Boertes, I don't think I'm going to preside over this matter. Kindly remove the matter from the roll and or tend to the senior motion court judge as a result of what transpired, and I had no difficulty with it at all.
Yes. Then in paragraph 11.7 on page 52 of your statement of response, you refer to the fact that you went to see Judge Makhubele on the 14th of November 2017.
That's what I testified to in Chief Chairperson.
At her offices in PRASA's headquarters in Hatfield, Pretoria.
That's correct, Chairperson.
And
In Burnett Street.
you say in paragraph 11.8, Judge Makhubele and yourself did not discuss the merits of the matter during the aforementioned meeting. Do you see that?
I see that, Chairperson.
Can I ask you this? Why did you consider it important not to discuss the merits of the matter with her at that point in time?
For a very valid reason, to provide Judge Makhubele with the documents so that she can exercise her discretion without me influencing her before she had an opportunity to read the 17-page bundle.
Yes. And then at 12.2, at the bottom of paragraph, page 52, you say, Matopo and Krauser and I consequently decided that I should provide Judge Makhubele with information requested by her to cooperate with her in pursuit of finalization of the matters. We furthermore agree that I will keep them up to date with the correspondence or messages exchanged between Judge Makhubele and I, specifically to avoid any misunderstanding or confusion. Why was it important for you in the course of any discussions you'd have with Judge Makhubele?
For two reasons, Chairperson. One, to be transparent. Secondly, we're dealing with public funds. The last thing that I want to become involved in is a dispute, like I alluded to earlier on, he said, she said.
And that's why there was a proper written record of your conversations.
That was what I attempted to keep, so as to, for that specific reason. Sorry, there was just something that distracted my attention.
Right, let's wait and Are you ready to proceed with your
Are you
response?
still going to be some time, Mr. Malay?
Judge, I think I need about 45 minutes.
45 minutes?
Yes.
No, I just want to know, because I believe the witness is not available tomorrow.
Yes, I understand.
But if you require about 45 minutes and there may be some re-examination, we'll have to ask him to come back on Wednesday, I believe.
On Thursday, Chairperson.
Thursday.
Let me just clear this. We'll have to ask him to come back.
Yes.
And unless there's a point you want to finish, if you
No,
want to move
I'll
on
leave it for Thursday. I was just going to finish on a point which would require more time. But let's leave it for Thursday, whenever it's available.
Yes, thank you. Thank you.
Thank you, Judge.
Yeah, Mr. Boertes, it looks like we are not going to finish with your evidence today. I have been informed that you will not be available tomorrow and may not be available Wednesday, so we will adjourn the remainder of your evidence till 10 o'clock on Thursday. What will be the date? Whatever the date is on
The
Thursday.
18th of May.
And on the 18th of May.
Thank you, Chairperson.
Yes, then we will take today's adjournment then, Mr.
Thank you, Chair.
Yes. We will then stand adjourned with this witness until the 18th of May, but we will convene tomorrow and see what the evidence leader has in store for us.
Thank you, Chairperson.